bench. But the urgency is, my lord, there are two appeals, one from injunction application, for injunction order, and one from the attachment order. Lordship, the next date fixed is on 11th. On the last occasion, a point was taken that since a new extension has been granted, my earlier appeal that has become infructuous, a new appeal should be filed. Lordship, we have now prepared this. 1st August was the date. We had prepared this, but the certified copy we could not get. The next date is on 11th. So, my lord, when Mr. Honorable Justice Tandon comes back, Lordship, again at point will be taken again from 11th order of extension. We have to file another. So we are, my lord, in the loop of keeping on filing. Lordship, and I'm praying that these two appeals and those two appeals that may be placed before your Lordship, because otherwise, Lordship, after 11th again, my lord, the same point will be taken.
My lord,
I'm grateful.
The interim order was extended without hearing your objection.
Lordship. And it's clearly covered with section and arbitration clause.
No, give notice to the other side.
Lordship, immediately.
Kalke request for the Yes,
my lord, okay, need your leave to file without certified copy.
when the order was passed,
The order was passed on 11th. I have applied for the order.
which determination?
My lord, this is Matt challenging and impan order. Honorable Justice Ajit Ganguly.
When did you apply for the certificate copy?
On 11th, my lord.
July is the order.
My lord?
11th July is the order.
Yes, my lord. The next date of hearing is on 16th. So we have to file this. My lord, can it be fixed on Monday, my lord?
Yes, call the list.
To be mentioned, item number 1.
The hearing was concluded yesterday.
To be mentioned for correction? Won't file the issue. We want the state because they have given a note which is referred to few documents, but that was not part of the note.
State
First of all, is there any amendment to this West Bengal Primary School Act? Because they referred to an amendment, but that amendment is not part of this record.
No. Act is of 1973, my lord.
No, there is an amendment they say in the note. So we could not find the amendment. They say this is annexed to this note, but we could not find it. that is why we kept it for this. Then they say there is an amendment to the NCTA notification, which is of 29 July 2011.
Malad, that notification I can supply your lordship by.
That notification is not here.
Malad, I can supply, Malad.
But
Within Malad, few minutes, Malad, I will
that is
make
one thing.
photocopy.
That is one thing. Secondly, we need the AGP. Where is the AGP? Mr. AGP?
That is the AGP.
Next thing is
AGP ka ana ko kothin. AGP is junior. Hey, and his junior is here.
next thing is
Notes are accepted.
দাঁড়াও, এটা খোলো আমার এই ফাইলটা so far as this para teachers are concerned, in terms of the 2016, both the things. In note 7, it says that provided that the qualifications for such categories of candidates shall be the same as mentioned in these rules. Yes, yes. In your note, we could not find the amended notification of the NCTE. It says enclosure 3, but we don't find any enclosure 3.
Yes, page 14.
14.
14. It starts at page 14. First in Hindi
No,
version.
that is 2010.
10.
Then you say amended. In amended, you say amended on
But qualification remains the same.
copy of the notification of 29 July. There is no copy of the notification here.
Sir, তাহলে supplementary
Lordship is reading page 5, Malad.
supplementary কত কত জুলাই তো
29 July 2011. That is one thing we require. Second thing,
July 2011.
yes, that is required. Second thing is
29 July 2011.
2000
if you come to paragraph 4 of your note,
Paragraph 4.
last sentence, but the act of 1993, which act? 1993?
No, it should be
1973,
97.
97.
No.
But the Act of 93 applies to secondary schools as mentioned in
Act of 1997.
90. School Service Commission.
Now, the School Service Commission Act also applied to class 10.
Class 10.
Which provision? Give us that. School Service Commission Act.
That I have given my lot.
Yes, you have given. Correct. That you have given.
Definition of teachers and definition of school. Section 2 and R. Thank you.
Section 2P defines teacher.
Section 2.
Section 2.
P.
First definition of school.
No, so it will apply to both secondary and high secondary. Both secondary and high secondary. Very well. Now,
একবার দেখে নিচ্ছি
এটা 2093 লিখবে 93 কি করে দিতে 93 কোথা থেকে দিতে আসলে দেখো না
চাইছেন বলুন
so you will supply us this 29 June 2011 notification and
জানি মনে আছে লিখতে হবে Malad 29 July, Malad, I am supplying, Malad, immediately. Malad, I just go outside and Malad make photocopy and Malad supply your lordship.
hey, affidavit affidavit before the trial
Yes.
court.
No, all a report in the form of APT.
No. Before this honorable single bench, nothing was filed.
Before the learner signature, no affidavit was there. Disposed of. At the motion stage, it was disposed of. Without calling for a affidavit.
যেটা আমরা টিউশন বেঞ্চে ফাইল করেছিলাম অরিজিনালটা টেস্ট আউট করছিল না বলে আমরা আবার একটা
But our original, which report was filed, that was filed in the department, that was not traceable. Then we filed a Xerox copy of the report.
হ্যাঁ বলা দরকার নেই স্যার ছেড়ে দিন ডিপার্টমেন্টে ফাইল করেছিল কিনা annex করে নিয়ে করে দিয়েছি
Now, in your written notes, you have said that yes, come to your paragraph 3.
এই 29 জুলাই
Training means training referred to the notification.
No, you see, you have referred to National Council for Teacher Education Act 1993. So that 93 matches with this, you said 97. You have said,
Act has been amended after the judgment of the Supreme Court. Initially, Supreme Court.
but the act of 1993, that means 1993, you meaning thereby this National Council for Teacher Education Act 1993. So why you say 97? But the act of 1993 also applied to,
Sorry, National Council for Teacher Education Act 1993.
so that is why 1993 means at page 3, not the 1997 act. It means to that act.
আলাদা
It means to that national,
No, sorry, but it will be 93 because that I.
yes, that's what I'm saying. So this 93 is correct.
Yes.
আচ্ছা
So if we are confused, then there will be problem.
29 জুলাই এর নোটিফিকেশনটা একটা কপি আছে
So,
29 July,
so
after
this-
only one.
so this 93 means the National Council for Teachers Education Act. Will it be available in the headmaster manual? No.
But I will supply copy.
We need this copy of this act.
But 29 July 2000.
সিঙ্গেল সিঙ্গেল
Ninety-three act রয়েছে, there, it's there in the school code.
শোনো, National Council for Teacher Education Act 93 বের করো না দুটো কপি।
That's there in the school code.
হ্যাঁ?
In the school code, it's there.
স্কুল কোডটা দাও তো।
Let me, I find it.
স্কুল কোড। আরটা কোথায়? এখানে তুলে রাখো না কেন, আমি উঠে যাওয়ার পরে। হ্যাঁ? এটা ভলিউম 2।
National Council of Teacher Education Act is not there.
না না,
না স্কুল কোডে নেই স্কুল কোডে নেই
School code is not.
Let me, I find it.
Give me,
স্কুল কোড দুটো ভলিউম আছে। মনে
give me this night time, tomorrow in the morning, I will supply the copy.
কালকে কেন?
কি কি
NCT Act.
আমার ডেনসিটি একটা আমি সাপ্লাই সব আছে
You know? So give us this National Council for Teacher Education Act.
And 29 July.
So this NCTE Act is applies to secondary schools
Because it was amended in 2011.
by this by the amendment now you are handing over this amendment. By reason of this amendment.
Yeah.
This notification.
No, but a central government, Parliament amended Act of 1993 in 2011. It was up to whether teachers of the training institution, it had been extended to the students also. teacher's qualification also.
Malad, it was affected, Malad, since 2010. Malad, there was an order of Supreme Court. Malad, this act was not, Malad, in force. Malad, it was implemented, Malad, since 2010. NCT Act, 1993.
NCT Act is of 1993.
Yeah.
Now, according to you, this act was also applied to secondary schools as amended in 2011. So you have to give me that amendment of 2011. That is required.
2011 একটা একটা কপি একটা কপি
No, 2011 acted amendment.
হ্যাঁ
আচ্ছা, আপনার কাছে?
এই নোটিফিকেশনটার একটা কপি
Affidavit of the state, দেখি affidavit of the state. Paragraph 3, you have referred to affidavit of the state. Affidavit of the state filed in this proceeding. Paragraph 3, affidavit. তুমি 1993 টা বের করো, 2011 টা বের করো।
It's 23. Sorry. 4 January 2023.
বলছেন এই এফিডেভিটটা কি এই কানেকশনে আপনারা ফাইল করেছেন?
This connection with this,
Where is that affidavit?
এফিডেভিটের কপি
Page 19 of the affidavit, which affidavit?
but there are two affidavits, one affidavit, then supplementary affidavit.
No, this is supplementary affidavit.
And original affidavit is also there.
We do not find anything, any of this
But I
document.
will supply the copy again, 1 second.
No, we do not find. One is in opposition on behalf of the respond number 45.
Pages.
আর কোন affidavit আছে?
কপি আছে
এগুলা না, এটা supplementary. Stated একটা affidavit আছে affirmed on 4th January 2023. Where is that affidavit?
সেটা অরিজিনাল কপি নেই ওদের বোধহয়, জাস্ট ওদের কপি দিয়ে জমা দিয়েছিল যতদূর আমার মনে আছে।
No, I will supply the copy.
No, we want to finish it up, so we want to have a look at it.
Lord, here's another copy. This was affirmed on 4th January 2023.
4th January 2023.
This is the affidavit. Report in the form. আর কিছু না, এটাই। It's a report in the form of affidavit.
What is the form of affidavit?
Affirmed on 4th January 2023 by the School Education Department.
Page
Page 13.
Page 19.
Page 19.
Page 19.
What is this document?
স্যার এইটার কথা বলছি
এটা অ্যামেন্ডমেন্ট আমাদের
This is an amendment.
Amendment to the primary teachers.
রিক্রুটমেন্ট 2016।
Lord, this is an amendment.
Page
Very
19,
well, very well.
small r. Training means.
Refer to the notification of 23rd August 2010.
Yes, that I placed before all of.
This perhaps has no relevance.
তাহলে অ্যামেন্ডেড কপিটা আপনি স্যার দিয়ে দিচ্ছেন তো?
হ্যাঁ।
এনসিটির অ্যামেন্ডেড কপি,
হ্যাঁ।
ঠিক আছে। তাহলে আমাকে আর কিছু দিতে হচ্ছে না, আমার কাছে এনসিটি অ্যামেন্ডেড কপি নেই,
হয়েছে।
অ্যামেন্ডমেন্ট হয়নি তো আমি কোথা থেকে দেবো? তাহলে আপনি দিন, ওই এনসিটি পাশে দাঁড়িয়ে আছে, জিজ্ঞেস করুন। ও তাহলে সেইটাই বলে দিন, 29 জুলাইটাই অ্যামেন্ডমেন্ট।
29 জুলাইটা দিলাম
সেটাই তো আমি বলছি।
না, 12 তো হয়েছে, 11 না 12।
তাহলে স্যার আমার কাছে
I will supply me.
অফিসে চলে যাওয়া হয়ে গেল। হ্যাঁ, ইন্ডিয়ান সায়েন্স কংগ্রেস আছে, একটু কাজ করছে। এটা হচ্ছে এনসিটি না, এটা হচ্ছে প্রাইমারি অ্যাক্ট, এনসিটি অ্যাক্ট এখানে আছে। এই তো এনসিটি অ্যাক্ট, এটা
Now this, which provision, in the note you have said that the right to education. That is section 17 of the West Bengal, which act? West Bengal Secondary Education Act. West Bengal School Service Commission Act.
Yeah.
Section 17.
Yeah.
School Service Commission Act দেখুন। ও এখানে আছে চলো।
April 2017 it was amended.
17th April.
2017.
No, you have handed over the School Service Commission Act.
It's a once,
Yes, yes.
last document.
That's the Control of Expenditure Act, not the School Service Commission.
Act for control of expenditure of 2017.
No, no, you said in your note that in terms of section 17 of the West Bengal School Service Commission Act,
Yeah.
you could not
Okay.
find anything, any such provision.
Section 17 of the school service.
রেলিভেন্ট ওটা শুধু এটা রেলিভেন্ট নয় কি করতে দিচ্ছেন
এখানে লাগাই দেবো। পাঁচশো কোটি করে।
এটা কোনটা? এটা লাগানো হয়নি কিন্তু এটা তো আলাদা।
Sober or up to date?
এটা একটা আলাদা কপি স্যার, এটা লাগানো হয়নি, এটা একটা আলাদা কপি। এটা আগের দিনে ওখানে হ্যান্ড ওভার করেছিলাম, এটা আমাদের কপি। এটা কোনখানে বলছে এই যে প্যারাগ্রাফ 7টা দেখুন।
Section 17 of 1970.
না না এটা
You
কি
said
বলছে
section
না,
17 of the
আগে-
1997 Act, but we could not find any section 17 in the compilation that you handed over. You ends at section 16.
Oh, sorry.
West Bengal School Service Commission Act
This missing.
হেডমাস্টার ম্যানুয়াল থেকে কোথা থেকে বেরোবে? না না, হেডমাস্টার ম্যানুয়াল থেকে বেরোবে।
এর আগের
এই
দিন
বইগুলো কেন ফেরত পাঠিয়ে দিচ্ছেন না বলুন তো? এই যে এই বইগুলো, এই নিচের বইগুলো ডুপ্লিকেট কপি। হ্যাঁ,
কথা নেই তো,
এটা মাদ্রাসা।
সেকশনটা নেই সেখানে। ষোলোর পর আর নেই। বিশ্বাস করা তো মুশকিল।
প্রিন্ট করে লাগানো হয়েছিল ওটা, বই তো রয়েছে।
কি
স্কুল সার্ভিস কমিশন অ্যাক্ট।
না নিয়ে আসুন, রেলিভেন্ট নয়, আমি কেন নিয়ে আসবো? আমার এখানে নেই, চেম্বারে আছে হয়তো।
আমার তো
There's an amendment act in 2008. এরাও তো অনেক চলে গেল, একটা এক দেখছিলাম।
go out of
Amendment. Where is the West Bengal School Service Commission Act? Where can we give you? Is it here? Please find out. Hey, education manual.
হেডমাস্টার ম্যানুয়ালটা আমাকে দিন।
Education manual.
হ্যাঁ ইনফর্ম বলে দাও না আজকে লাইনে আসবো
490, yes, এখানে page 490 there. Yes, we got it.
একটাই নেই
আর ওই অ্যামেন্ডমেন্টটা বের করতে হবে, অ্যামেন্ডমেন্টটা 2011।
বাড়ি সাহেবের স্পাইরালটাতে বোধহয় স্কুল সার্ভিস কমিশন একটা দেওয়া আছে বাড়ি সাহেবের স্পাইরালটা
Power to make rules. Power to make rules, section 17.
That is section 17.
Section 17.
So Right to Education Act, you said that it was made applicable under this act.
Yeah.
Which provision?
No, Right to Compulsory Education Act, section 23 of the act.
Requires the government to make frame rules.
No, academic was NCT. NCT. NCT.
2010 clarify. 2010 মানে তার 2009 Right to Education Act came into operation with effect from 1st April 2010
Yes.
by a provision of section 23 of the act, RTE Act in short. The academic body NCT was appointed as academic body under section 23 subsection 1.
Section 20.
23 subsection 1 of Act RTE Act 2009 with the power to lay down the minimum academic qualification which is applicable for primary to upper primary the teachers for recruitment. Subsection 22 of section 23 NCT framed the guideline in 2010. That is on 23rd August 2010, first notification published by NCT and laid down the minimum academic qualification applicable for
Which was subsequently amended in 2011.
29 July 2011
2011.
Now it refers to academic authority means NCT.
NCT.
Academic authority is defined.
That is not as in terms of subsection 1 of section 23 of RTE Act.
No, academic authority authorized by, so NCT is the academic authority authorized.
Yes. By the central government.
No, is there any notification to that effect?
There was a notification.
No, NCT will be because it doesn't say about NCT as such, as laid down by the academic authority. The academic authority is defined in the act.
Academic authority not in the act defined, but academic authority in the act has been defined that the central government will decide and will make a public.
Academic authority authorized by the central
Yes,
government.
therefore NCT has been authorized.
No,
in
is
terms
there
of
any
section 33 or 32 of the NCT Act 1996.
section 32?
But the Lordship, can you excuse me, madam?
Yes.
আপনি এখানে আসুন
সবাই ধরে গেছে
আমার 26-এ
ছাড়িয়ে দেবে very well.
upper primary
NCT কোনো
latest amendment 2008 upper primary তে দিতে পারবে qualification থাকলে BA 50% marks
The next thing is this where the AGP is required for the answer is that if you come to the 1996 Act or rules rather rules
96 rules ছিল 97 rules
96 rules
96 না কোড বলছে 96 rules 96 এ
Now it prescribe note 7, come to note 7, below note 7. So, the state government may by notification such and such. The
My lord is reading from page 7.
the compilation handed over by the appellant.
Barijan.
Yes, in any event, primary rules. The
Jain,
primary
Jain,
rules.
Rainy. Oh,
No, the primary rules. Look at the rules.
2016 rules বলছেন জজ সাহেব
For the primary level. For the primary level.
recruitment rules 2016
For the primary level.
yes
primary level.
Yes, my lord, 2016 rule.
After note 7, provided that the qualifications for such categories of candidates shall be the same as mentioned in these rules.
My after note 7, my lord, provided that the qualification
পড়া যাচ্ছে না, এটা দিয়ে লাভ নেই। পড়া যায় এরকম দিতে বলে। এখানে কি প্রিন্টারের প্রবলেম?
mentioned in these rules.
তো প্রিন্টারে চেঞ্জ করতে হবে। So, provided that the qualifications for such categories of candidates shall be the same as mentioned in these rules.
yes
Then which rule would provide? Because NCT has made a rule in 2011 amended. And if you go by, because now the para teachers will have to qualify which rule? Because by under these rules, he has to qualify for the rules mentioned in these rules. So is it overriding the NCT rules?
my lord,
amending?
my lord, so far the NCT is concerned my lord there is no my lord, provision for para teacher
Yes.
only my lord, primary rules 2016 rules my lord, the para teacher is there
2016 para teacher is there,
Hello.
but you are saying that this is governed by the NCT rules.
my lord, NCT only frame the my lord, basic my lord, the rules
Basic,
my lord,
yes.
basic
Minimum
minimum
A
qualification
minimum qualification for consideration for 1 to 5 and 6
6
to
to 8.
8. So 1 to 5, so far as, so rules would mean that even for a para teacher to qualify for this 10% will have to have the qualification as that of the primary teachers,
primary teachers
as of the primary.
primary
teachers. That's a clarification.
If it is so as per NCT guideline, for 1 to 5 minimum qualification, 50% marks in graduation and my lord B.Ed or DLED,
So that is for the NCT.
NCT.
Now, so far as when we make the rule, when the state makes the rule, then these rules must be in addition
In
to.
consonance with the NCT, if they so.
No, but there is not in consonance. These rules, whatever the rules the state has made, is not in consonance. Whereas you see the rules, the qualifications are at page 5, the academic qualifications.
my lord, qualification your lordship my lord, rules say
No
no
person
person
shall
shall
be
my lord,
appointed by council.
my lord, position my lord, 6-2 my lord, the candidate shall possess minimum educational qualifications specified by the National Council for Teachers Education and notification relating to eligibility
Yes.
of candidate issued by Ministry of Human Resource Development, Department of School Education Literacy, Government of India from time to time read with the relaxed qualification issued by the MHRD and pass the TET. My lord, this is the only my lord, the minimum qualification prescribed by the NCT. And my lord, that is my lord, followed by the government in toto.
No, this is in consonance with page 5. The 8.3 is in consonance with that.
That is relaxation provisions, I find from.
No, procedure for selection.
That is
Yes, my lord,
subsection 3.
and my lord, 8.
Table A is exactly parameteria with the
My lord, NCT, what NCT has done, my lord, this is the basic, my lord, NCT has said 50% in higher secondary. Now, my lord, in the process of selection, my lord, the government has framed rule, what is the criteria, what is the, my lord, the madhyamik, the marks in the madhyamik higher secondary, my lord, this is the table A, marks in the madhyamik higher secondary training, my lord, teachers eligibility test.
No, this is basically for recruitment of the primary teachers.
Primary
No
teachers.
problem.
No problem.
Now, in this, if we are making a vacancy for 10%,
Earmark.
filled up earmark. Earmark reservation meaning the same. You reserve it for para teachers in effect. So this 10% will be filled up by by para teachers. Now, for the purpose of qualification of the para teachers, what would be their qualification? If you go by this,
8.2.
if you go by this note 7
my lord, that your lordship has provided that the qualification for such categories of candidates shall be the same as mentioned in these rules.
So this para teachers for also,
Is primary rules.
so NCT rules, if it is at variance, suppose NCT rules is at variance with the rules you made, then what would happen?
My lord, then entire rule will go. My lord,
No, for them only, 10%.
my lord, there is no, my lord, contrary to the NCT. My lord,
No, I have
if
to
the
check
primary rules is not contrary to NCT, then also para teacher cannot be contrary to NCT because, my lord, here it is said,
No,
provided
8.3
8.3 relaxation.
8.3 is
Oh, sorry.
with regard to the academic qualification.
8.3 of,
8.3
8.3,
procedure of selection.
yes, my lord.
So
Academic
this
qualification.
academic qualification is same as that of
NCT.
as that of, now you see the NCT relaxation, NCT qualification.
Yes,
What
my
does it
lord, I
say?
have. My lord, 29 July.
29 July 2011.
11.
That is the amendment. And thereafter further amendment took place in 2018. 28 June 2018. Further amendment took place.
28th June.
28 June last amendment only with regard to minimum qualification for primary teachers
No,
where
ওইটা
B.Ed
দরকার নেই, এখানে 11 নয়।
B.Ed was incorporated for primary and applicable for primary with 50% marks in graduation. That is in additional.
My relevant is 29 July.
29 July 11 is relevant. ওই নোটে ওদের নেই 2018 এনসিটি
না দাদা ভুল বললে কথা থেকে করতে কিন্তু
তোমাদের কি নোটটা কোথায় দাও না একটু। এটাই
না,
নোটটা দাও না তোমাদের বুঝতে পারছি না কি লিখেছো আমাদের সার্ভিস
29 July, my lord, I have, my lord.
তোমার কাছে দাও না সেটা দাও না
হ্যাঁ। They have handed over, my lord, a single page.
না,
Mr. Mukherjee, my lord, handed over a single page, my lord.
ওটা annex করা ছিল না মনে হয়?
ওটাতে তো
This is
মিনিমাম
13th October 2011.
Yes, my lord.
13th October.
My lord, 29 July
29 July madam. Date of notification 29 July 2011. At the top madam it is written.
Or your lordship can also, my lord, see 10th
No,
August.
it was notified on 13th October 2011.
Notified but date of notification madam as per NCT record 29 July 2011.
Which rule?
At the top one was the
which
copy.
My lord, once your lordship kindly see, my lord.
Kindly see from the NCT guidebook. It is there.
একবার দিন তো এটা জজ সাহেবকে।
Copy of the notification of 29th July.
ওটা
Copy
একটু
of the
কম্পেয়ার করে
notification.
নেবেন একটু জশকে দিন।
29th July কোনো notification পাচ্ছি না। This is not a notification of 29th July.
Well, for a moment, may I take back this thing?
না না না
এটা কি?
এটা না এটা না।
This
No,
is an
my lord,
amendment.
this is different. This is different. Kindly see this book, my lord.
No, we need to have a copy. We cannot mark it here.
একটা কপি
my lord, just now they have handed over একটা কপি সিঙ্গেল কপি দিয়েছেন তপন দা।
সেটা কপি করতে বললাম সেটা
এই মাত্র একটা সিঙ্গেল কপি দিয়েছে।
তাহলে ওকে একটা কপি করতে বললাম তো কপি করে কোথায় না না ওকে এটা দিল
আপনি ওখানে কপি না করতে পারলে সার্ভারে পেয়ে যাবেন।
জাস্ট কোনো কপি দেয়নি কপি দেয়নি
দিয়ে দিন একবার আমাকে দেখিয়ে দিন তো জাস্ট ভেরিফাই করে
I think that was set out also.
ইয়েস মানে
হ্যাঁ।
দিস ওয়ান
হ্যাঁ এদের
আরেকটা
কপি
copy
করতে
দিন।
বললাম তো।
আরেকটা কপি আমাদের একটা কপি দিবেন আমার কাছে তো ওটা তোমরা মুশকিল হয়ে গেল আমরা
So
ওখানে
if you find it, if you compare this with the compare the qualifications are the same.
My lord, yes. My lord, yes. Your lordship kindly see, my lord. One, minimum qualification.
Yes.
Senior secondary with at least 50% marks. My lord, therefore, my lord, 10 plus 2. Senior secondary, at least 50%. My lord, this is the minimum qualification. Here, your lordship, Also, my lord, rule 6, your lordship will find 6(2) proviso 2, that minimum qualification as laid down by the NCT. And my lord, your lordship is asking about the, my lord, saying about the table A. My lord, table A, it is, my lord, the computation of marks. My lord, how, my lord, the selection process to be, my lord, this is only for the, my lord. Here your lordship will also find, my lord, Madhyamik and Uchcho Madhyamik, higher secondary.
So any primary teacher, if having this minimum qualification in terms of this NCT amended notification,
50% in higher secondary or graduation.
then that means to say that the teachers and para-teachers will be at par. Will be
Malad, basic qualification, they must have, malad, 50% are higher secondary or graduate.
If you are putting teachers and para-teachers at par, then the concept of para-teacher goes, why they should be treated as
Yes,
para-teachers? They should be
absolutely correct.
100% teachers. Why the
100%.
para-teacher?
Why you
No, 100% teacher, your lordship is absolutely right.
10% of para-teacher doesn't-
Only, malad, only 10% earmark only from the para teachers who, malad, I tell you,
are
lordship,
already in existence.
in existence, only, malad, for them only this 10% was earmark.
They are in service.
They are in service.
Only for the existing person.
Only for this. Because nowadays, malad, what Mr. Mukherjee yesterday, malad, trying to say, nowadays there is no appointment of para teacher.
No, so this is if the para-teachers are already in existence.
Only category of para teacher only reserved for 10%. Only category. Those who are in service, para teacher.
Those who are continuing prior to 2010. But there was no guideline for para-teachers. Was there any guideline for
Well, at
para-teachers?
that point of time, there may be, malad, those who are appointed as para teacher, malad, at that point of time, there may be a guideline.
100 the way. তার সঙ্গে 10% হচ্ছে না 110 হচ্ছে
না, but কি বলছো?
পোস্টার
Total vacancy থেকে 10%.
টোটাল ভ্যাকেন্সি থেকে 10%. তুমি আবার উল্টো বলাচ্ছ।
তাহলে কোনো প্রবলেমই হতো 110 জন কাজ
কালকে গন্ডগোলটা পাকিয়ে গেছে তখন
তোমাদের 110 জন বলেছে
ওইটা আছে।
এনসিটি গাইডলাইন কি ওদের তো ইন সার্ভিস ওদের ক্ষেত্রে রিল্যাক্সেশন আছে 10%। তো সেটা কত একাডেমিক কোয়ালিফিকেশন
না, একাডেমিক কোয়ালিফিকেশন
আর দে কোয়ালিফাইড
হুম,
তারা
মিনিমাম কোয়ালিফিকেশন না থাকলে কি করে পাবে? টেট পাস করতে হবে।
Serving at present.
Yes, my lord.
But that has been clarified in the notification issued by the governor, but that is not in the rules. That
Notification.
That 10% in the rules when you made, you did not say that this 10% of the total post for the candidates belonging to para-teachers. So it gives an impression that you will create a 10% quota for the para-teachers.
Fine.
That means it may contemplate a fresh recruitment.
No, my lord.
It contemplates a fresh recruitment unless it is clarified by the subsequent notification.
Lord, 10% of the total vacancies which are to be reported to the board in terms of Rule 4 of the recruitment rules.
This is a recruitment drive,
Yes,
so it's a fresh appointment. You are recruiting for the post.
yes.
So there has to be, so if he's under this, you have already a primary education. There is a
Yes.
recruitment for the primary education already in place.
Inclusive of this,
Prior to 2016, think of it.
prior to 2016, my lord, the board never used to
Yes,
cause the
yes,
recruitment.
yes.
Yes.
2012.
To 2012.
Prior to 2016, there must be recruitment of primary teachers.
Para teachers.
Primary teachers,
Primary
Yes.
teacher, yes.
because you have an Act of 73. So under the Act of 73, there must be recruitment of teachers.
Yes,
So that must follow, that
Yes.
was a procedure.
yes.
In 2016, what we have done is this, you make a change to that procedure, by which now 90% will be for the teachers, will be
For the
from
candidates.
from the candidates, and 10% para-teachers.
In-service para teachers.
In-service para-teachers is not mentioned here.
My lord, para
So,
teacher
In
itself
Rule
says, my
7,
lord.
it doesn't mention about in-service para-teachers.
টিচার কথাটা টিচার তবেই তো যে দুটো চাকরি করছে তাই জন্য তাকে টিচার বলছে, প্যারা টিচার।
You know, unless somebody is appointed by Sarvashikha Mission as a para teacher, he cannot be a para teacher.
No. Sarvashikha Mission is 2010,
না, তার আগে
or
Last
maybe
2000.
prior there. So whoever was doing under the Sarvashikha mission, they were to be considered as para teachers, according to
Yes,
you,
yes.
because there is no rule for para teachers. We have not seen any rule for para teachers. Now, para teachers, you say that for the primary teachers now, we do not know what was prior to 2016 rules. For the para teachers, they were not coming within the purview of the West Bengal Board of Secondary Education, Primary Education. They were not, because how they will come under this provision? How they will come under this provision?
Malad, if Malad someone,
There has
The-
to be a government circular guideline, financial sanction for the creation of posts.
no, Malad, there is no creation of post. Malad, suppose vacancy is Malad 100.
Yes.
Malad, out of 100,
Right.
10% number of Malad.
That is now by reason of these 2016 rules.
Yes.
Yes.
Prior to 2016 rules, all are recruited directly or through the process, whatever is there.
No,
So
para
para-
teacher was there. Was there.
No, the query of the court,
12 also there, Dada. 12 ও ছিল।
the query of the court is how they were recruited.
Yes, how they were recruited. Prior to 2016, there was no rules for recruitment of para teachers.
There must be a rule.
No, we cannot say in vague.
No,
There has to be a rule or there has to be, there is
Specific.
no rule.
My lord, para teachers were never recruited by us. It was channeled through the Paschim Bango Sarvashikha mission.
Yes. So they have a, if they have a separate channel now by reason of these rules, they are brought in within the purview of the West Bengal Board of Primary Education.
As primary teachers, if they qualify.
May qualify as a primary teacher. So these para teachers having this qualification will now compete with others to be considered for, if the existing para teachers who are there, they now be considered as
Primary
quote, as
teachers.
primary
teachers,
teachers.
provided they conform to this.
Yes,
So now they are really getting an umbrella of a statutory, of a
yes,
statute,
yes,
protecting their service.
yes. Anything else, my lord, we can assist?
No, but I think you have given all the documents we need. এই একটা কি বললাম দিতে ওটা বের করেছে?
এটা কি আমাদের?
ও নোট একটা দিও তো কি দিয়েছে
Order হলে হবে।
অথচ আমার
আনবো?
ব্যাক হয়ে যাচ্ছে বুঝতে পারছি না কোনটাই চলে যাচ্ছে কে কি পয়েন্ট নিচ্ছে ধরা যাচ্ছে না অফিস সার্ভিস করেন
চলছে 11:30 বাজে।
এটার জন্য কারা বলো তো রাতুল সব আছে মালগুলো সব ইলেকশনে কেটে কেটে
এটা কি করে হবে? এটা তো আমি 10 এর দেখো। হ্যাঁ, 10 করে তো প্র্যাকটিস অ্যাপয়েন্টমেন্ট হয়। আগে গভর্নমেন্ট ওদের সিকিউর করে দিয়ে গেছে পুরো বছরের সিকিউর করে গেছে 10,000 টাকা মাইনে।
Anyone is appearing for the writ petitioners? No. Take down.
হচ্ছে
The hearing was concluded yesterday. However, while going through the record,
I to supply anything else.
All documents are now on record.
Much obliged.
Files are partly record. Yes, call the list.
Item number 2.
Yes, in that matter, I am for the application. This is application for restoration, my lord.
Restoration.
Restoration. That was dismissed on 18th January 2023, my lord. This is first time appear before my lord, this bench, my lord. As I have missed the list, so I could not appear. And knowing this said fact, I have filed this application with the section 5 application 100,
Have you
130.
served?
This is first time appear before your lordship, and with the before service that was dismissed.
At the admission stage.
First time on 18th January 2023 appeared before your lordship, before service of the copy to the other side.
Very well. The application.
Lord, I appear for the respondent. my lord.
Appear for the item number 3 and 4, my lord, we want to withdraw the matter, my lord. There was some
Draw the
technical-
matter. Very well.
My lord,
there was
I
some-
have some submissions to make, my lord.
Yes. Yes.
there was some technical error, my lord. What has happened? The memorandum of the memorandum of appeal was filed by the erstwhile advocate on record by the wife herself, by the
Well, you want to withdraw, that's fine.
my lord. We want to withdraw, man.
My lord, I have to make some submission. Lord.
You have
Lordship.
you have no right to say.
My lord, will kindly see the last order
Which order?
passed by the division bench presided over by my lord, Honorable Justice Harish Tandon, my lord. Lord, this matter was mentioned. Lordship is taking up this matter.
The matter go to the list. Yes.
My lord,
Because
what
of
had
the
happened?
technical error,
My
my
lord,
lord.
my lord,
Yes,
my lord,
if he wants to, because you cannot.
Lord, item number 4, Lordship will kindly see appeal filed by the minor, my lord. Lord,
Maybe if they want to withdraw this, fine.
my lord, order 23, rule 2, my lord, that,
Oh, appeal will not be maintainable, maybe.
my lord, that is, my lord, that was the question posed by the
They
Honorable
want to
Justice.
withdraw this matter, we are not
Lord,
deciding.
they tried that, the lordships refused, my lord, because my lord, lordship posed questions. My lord will kindly see the conduct thereafter, lordship. My lord, I leave it to my lord.
This, if they want to withdraw the appeal,
My lord,
the matter ends.
my lord, it's not as simple as what my learned friend is saying. Lordship will kindly see the conduct. In fact, my lord, this is what I had.
If it is not, has caused any prejudice to you, you have no right to say. It is at the admission stage. You have no right to say, no, this order has not operated against you. Okay, now, the law is well settled on this. You are not enjoying, they are not enjoying the order of injunction, detrimental to your interest. We grant counsel for the that
Both the
the
matters.
learned advocate on record for
Same. Item number 4 also same.
yes,
Great.
5.
দুটো matter
তিন চার হবে বলে থাকতে কোনো অ্যাডভান্টেজ দেয়
Yes,
My lord, item number 5, I am appearing for the appellant. I am praying for a short passover. My counsel Sudarshan.
possible is possible because you go to the main matter.
My lord, just give me 2
Not
minutes.
today, not today, next. Not today, next. Next matter.
Item number 6.
Yes.
My lord, I'm for the appellant in this matter. On the last occasion, your lordship directed.
Yes,
Your lordship
for
may be
this-
pleased to recall it is that matter where there were 2 vacancies available in 2 schools, but the commission rejected the issue that the petitioner cannot be given the said schools considering the number of students. Now, my lord, your lordship was pleased to direct the state to file 2 affidavits, one of the school education department and one is of DI. It's
Dr. Patro.
My lord, may it please your lordships, in this matter, I am appearing for state, my lord. My lord,
Directed the education
Yes.
department to file an affidavit. This
my lord, the affidavit is ready, my lord. The only one thing, my lord, on behalf of DI, the affidavit is ready, my lord. My lord, so far as the state education department is concerned, my lord, that has been placed before the higher authority for vetting of the facts. So, my lord, that would take,
But if these facts are available here, same facts,
my lord,
facts must be similar.
facts possibly must be.
may I
What is
just
the affidavit? What is the
my lord, may I
affidavit?
just
My lord.
say one thing, my lord. One thing, my lord. My lord, I had a talk with Mr. Chatterjee. Mr. Chatterjee has been very fair, my lord. The 3 schools now there, since there's a rationalization policy, my lord, there is a change of vacancy position today. Now, my lord, Mr. Chatterjee has said there are other vacancies available in the nearby location where there is a dearth of teachers and teachers are needed. So, my lord, if your lordship kindly grants us some time, we sit together and find out what are the schools where there are requirement of teachers, where the
Here's the
petitioner can
My
be
lord,
accommodated.
the second copy, may I hand up the second?
What is the first copy?
My lord, first copy is
My lord, kindly take my copy. This is Mr. Chatterjee has handed over to me today itself,
I have given.
today morning.
Yeah, I have
Yes.
given.
My lord, I have just briefly gone through this. If your lordship takes page from page 6 onwards,
My lord, in
there is a vacancy, practical vacancy available at Bhatpara High School at serial number 3, paragraph number 3.
my lord would find, my lords would
There is no vacancy.
Yes, I tell you, Lordship. If your Lordship take page 6, at the time of my application, my lord, kindly take serial number 2 English. That is the Bhatpara High School. But today also there is a vacancy at stated in the affidavit.
No, they have given the affidavit.
Yes, my lord,
They
serial
say
number
that in
3.
Bhatpara High School, the number of students till class 10 are 23.
Yes.
And the number of teachers for English subject till class 10 are 3.
Yes, apparently there is one vacancy for English subject
Apparently, there
teacher.
is one vacancy.
Vacancy is there.
In Bhat.
Yes.
Rationalization has to be there.
Yes, now my lord, only one thing, my lord. Kindly see at page 6. At the time when I applied, my lord, kindly see English. There were there were 3 vacancies. One is there, my lord. At the time I applied, my lord, kindly see vacancies are there as on 17th of November 2021.
But we have to see the ratio also.
Yes, that's why I'm submitting. Well, Mr. Chatterjee I had a talk with Mr. Chatterjee. He said that there are vacancies available in the.
But there's nothing on record. We cannot.
No, he will be coming with that.
My lord, if as the suggestion was made that if any other vacancy in India, the school can be found, I submit that if that is to be done, then I need instructions on that, and I will.
That can be resolved, my lord, because there are schools where there are vacancies.
I can put an effort.
The report in the form of an affidavit by the district inspector that
I must draw your lordship's attention to one fact. During pendency of this appeal, suddenly an administrative transfer order has been issued upon the petitioner. During pendency of this appeal, normally the tenancy was pending before the Honorable Division Bench, and the subsequent notification of administrative transfer, which has 26th of July, where the Division Bench has been pleased to hold that the tenancy is justified, it can be done. But during pendency of this appeal, before that, this judgment of the Honorable Division Bench came, and administrative transfer order has been issued.
No, but now that
Now
we
that-
cannot stay. That we
That will,
cannot
no,
stay.
I'm just placing before your
Not
lordship.
required.
Very well.
Not
I
required
was
at all.
just trying to place before your
So my lord, I will check if there is
Yes,
any
yes.
vacancy on it.
There are.
And if and now that you are transferred, your case for accommodating the nearby school does not arise.
No, this transfer has not given effect to, because it was stayed initially by the.
But now it has to have given
No,
effect
she has
unless you
not.
challenge.
She has not been. She has not been transferred.
But
Only it was
then
issued.
your case cannot be
No,
considered at
she
all.
was put under. I tell you, lordship, she was
You
put.
have been transferred to your post
Yes.
unless you challenge it.
No, I'm not challenging it. It was during pendency of this. I showed to the earlier division bench as well. So then they said
Now
it is
that
during.
now that the division bench has laid down the law,
Yes.
so
Yes.
tenancy they have a right.
Yes.
So this
That's what I'm submitting, my lord. Since tenancies of rationalization, rationalization is only tenancy. So she can also be rationalized to the nearby schools where there are vacancies. That's what I'm submitting. So it will help them. It will help them in a way.
for the land council for
Yes, she has not yet been. It has been recommended that she'll be sent to Sundarban.
so there is already a transfer order naming a school.
Yes, yes, yes.
So it must be on the basis of rationalization.
Rationalization, but it
So-
has not been given effect to.
That's a different issue.
Yes.
It
has not been given effect.
manner, you cannot ask for stay.
No, I'm not seeking stay. I'm just informing your lordship.
That an administrative order of transfer has already been issued.
During pendency of this appeal. dated 10th of February 2023.
Then nothing remains in this state petition.
My lord, since my claim is of
Nothing remains.
prior, let's see, my lord, let them come with whether it can be accommodated.
Where is the affidavit? You have filed an affidavit?
Yes, yes.
Where is the
My lord,
affidavit?
I showed this to the earlier bench also, then it was a view of the honorable court. Since it is the issue is pending before this honorable court is season of the matter, it may not be taken into consideration.
In terms of section 10C of the W. Final order of transfer.
Recommendation.
Yes, recommendation is. তারপরে করবে যে লাস্ট লাইনটা দিয়েছিলাম আমি যে লাইনটা দিই
I just noticed, my lord, in the affidavit, there is a clerical error at page 5, read with my lord, page 4 of my affidavit. My lord, may I kindly pray leave to reaffirm it, my lord, and file it in course of the day, my lord. Notification জায়গায় অন্য
You have already marked your affidavit.
My
What
lord,
is what is the
the
error?
annexure P1, my lord.
Yes.
My lord, that annexure P1 is supposed to be the notification, my lord. Wrongly, that paper has gone.
Anyways,
Leave
to come
is
with a
given
report
to-
also.
Leave is
Subsequent.
given to the
দিচ্ছ, তার তো দরকার।
which you change.
P1, my lord, annexure P1.
So
Yes,
P1 is not the document to which you have referred.
my
So you file the document.
My lord.
বললাম।
The
Has not filed any affidavit.
No, my lord, on the next day,
The time to file affidavit by the education department is peremptorily extended by the urgent date. The said affidavit shall also consider the aforesaid aspect of the matter.
grateful to Lord.
much obliged with your kind leave, my lords.
Grateful to Lord.
Yes.
Hearing matter 166.
I appear on behalf of the respondent number 125, that is the writ petitioners. That I am led by Mr. Ashok Kumar Banerjee, my lord. With your kind leave, my lord, just I may start, my lord, because he's coming just. If you lordship kindly
Mr.
permit.
Gupta, we require few things, few clarifications.
Your lordships wanted me to submit the balance sheets. Now the balance sheet I have prepared, I have brought my lord the entire calculations with regard to the amount given for the teachers by the NTPC Farakka. But I am told that the balance sheet relate to the balance sheet relate to the entire NTPC organization all over India.
No, I just, we just point out few things, the cows to the owner.
Therefore, listener number 3 may I file my notice of argument.
You have not clarified before the learned single judge. You see the affidavit of DAV. Who is for the school? Who is for the school?
For DAV, Mr. Haldar was affidavit to the school. That's what the bottom.
Just a minute, just a minute. Just a minute, let us first clarify ourselves and we'll.
বলছিলাম যেটা ডিএভি অ্যাফিডেভিট কত কথা বলছি ডিএভি
Page 399. Page 399. Second one.
ব্যালেন্স শিট It starts at page 399.
I'm just taking 1 minute time. I'll take a glass of water. I'll come back. I was standing outside. Yeah, what is স্কুলের ওরা স্টাফ নাই বলেছে সিস্টেম ছিল সেই মতোই মাঝে পেয়েছি
$399.
599. It's also in 599.
Oh.
I think this affidavit is filed in this appeal. Have you got it?
Yes, 599 I have got. Let me check up in whether this is the same thing.
Yes, same thing, but we marked it here, so just
Yes. Papia. No, my lord, this is a
Ms.
different.
Shulekha Ghosh.
But the 399 is Papia Mukherjee.
Very well.
That is DAV.
Yes. Now she filed an affidavit. Now she is importantly, she described herself as the teacher in charge of the school. Teacher in charge.
But possibly this affidavit is not of DAV.
Yes. I am the teacher in charge of DAV Public School, Farakka. Got it?
But this is, my lord,
This affidavit filed in the appeal.
filed in the appeal.
Yes, yes.
I'm ready.
So he described herself as a teacher in charge of DAV.
Yeah.
Under the MOU, you should have your own headmaster or principal. Now, in paragraph 2, he described herself as the teacher of DAV.
Lordship.
Fine. Then you come to paragraph 4. This is talks about the offer. The offer was given by NTPC,
Lordship.
not by the school of NTPC school. To run, manage such and such, to take over. Then paragraph 5 is a discussion between the society and the NTPC. No other school feature.
No.
NTPC.
NTPC. Because
so agreement was of 8th November 2001.
with NTPC again.
With NTPC.
Not the
Yes.
Not the managing committee.
Now come to paragraph 6.
Yes.
Renamed as DAV Public School 1. Then
the clauses of the agreement.
Yes. Then clause 3. Second sentence. The president of the society or his nominee will be the chairman of the. There will be a local managing committee of the school. The general manager, head of the project of NTPC Farakka,
Vice chairman.
or his nominee will be the vice chairman.
Yes.
So this board will have representative from NTPC and
DAV.
Yes. Now come to paragraph 6.
5:4.
5:4. Then come to paragraph clause 6. That the staff of the existing school functioning under present school management will not be the liability of DAV, and the society will not bound to absorb the employees of the existing school. So this assurance is given by NTPC, whatever on behalf of whatever existing contracts are there. However, the staff members under the existing school management, that is present school management, will be given a chance to attend interview such and such CMC to select the staff. If any staff member at present employed by at present school management for the existing school is found suitable, may be given employment afresh by the DAV. Now we have not come across any letter giving them such option.
No, that didn't happen.
So it did not happen.
It did not happen.
Now that if any of the parties here to at the time wish to terminate this agreement, then termination is not important.
No.
Then
29, if the school is
then at
closed.
any time the school is closed at the instance of NTPC, that is also not applicable. Then you come to page 606. It is referring to clause 6 of the agreement. I state that as per clause 6 of the agreement, the liability with respect to the
Page
previous
100
teachers.
Page 606.
Yes, previous teachers. It starts from the previous
Previous
page,
teachers.
paragraph 7.
Yes.
I state that as per clause 6 of the agreement, the liability with respect to the previous teachers of the NTPC High School Bengali medium has been determined. Now, how it is determined, we don't know. The specific points to be noted that the National Thermal Power Corporation Limited has several projects all over India, and several projects such and such are there run by some local committee. And as per my information, the existing teachers of the year 2001, meaning thereby 14 teaching staff and 4 non-teaching staff duly approved by the DI in 1994. In the local inspection sent to the district inspector, sent to the board for approval, with the recommendation for approval of NTPC High School, had offered 2 options at that time, either to transfer in other schools, in other state project run schools, or the staff members under the existing school management, that is this. Now, we have not come across any of this option letter, whether they were asked to go to other schools of NTPC. Factually, we want to know on this, whether this was
That was never
implemented.
disputed.
No, I say so
Opposition.
by as we place the affidavit, such and such. Then, but it is very unfortunate after these quotations are there from the clause. But it is very unfortunate that even after several advertisements for appointment of teachers for different subject categories, none of the writ petitioners applied. There's no question of applying. It is given 2 options, or ready to appear in such recruitment process. Now, the writ petitioners and some other teachers never became teachers of DAV public school. Rather, they have been given consolidated amount of salary paid by NTPC High School on October 2011 as per request of NTPC Farakka, but they have been obtained such consolidated amount as teacher of NTPC High School Bengali, and the separate set of teachers appointed by. So this amount was paid. This consolidated amount was how paid? By the NTPC directly to them?
NTPC direct, not direct, the NTPC to the school.
Through
management
DM,
committee.
through DAV.
Yes. No, not through the, to the school management committee.
The present school management committee, constituted in terms of MOU. Is there any evidence to that effect? We need to see the document. What document is there on this? You're giving the money.
I have brought out the documents.
No. Is it part of the record or not? In your affidavit, whether you have disclosed this or not?
Lordship, you are pleased to direct me to bring the balance sheet.
Yes.
Since the balance sheet relates not to entire organization of NTPC, they said, my lord, it will not be
Possible to
segregate. Therefore, they have on their own prepared, my lord, from their accounts, a chart, my lord, which they have handed over to us, that will show that initially, when the number of students were more, the amount that was being paid by NTPC to the school management committee, that was minimum, 1 lakh, 2 lakh, like that. It continuously increased over time. And towards then, since as I said, 30 students, ultimately 5 students, like that.
No, whatever is there.
Whatever
So
shortfall was
NTPC
there.
Now, this consolidated amount was paid by NTPC,
By
not the
NTPC,
school.
yes, no doubt about it.
NTPC had paid this amount. So we
NTPC had
take
paid
we
it
take
entirely.
that we record your submission. that
Whatever
NTPC
shortfall was there, NTPC had.
No. This consolidated amount, because we don't want to put incorrect facts. So this consolidated amount, as said by DAV, has been paid by NTPC. Is it through DAV or independent of DAV?
Not through DAV as such, to the school management committee.
Is there any such resolution or any such document to show? If you have, please show us any such document. How these amounts were paid. Of course, the writ petitioners will also be in a
The
position to
agreement, if your lordship kindly takes the agreement in the first volume, there it is, there is a clause like that the NTPC will remain bound to pay to the local management committee any
all the shortfalls.
all the shortfalls. in
Not all the
regard-
shortfalls for the building and other maintenance, such and
No.
such things.
For in entire shortfalls, administrative expenses up to one ceiling of 1 lakh, but other expenses entire shortfall. Clauses 19 and 20.
No, whatever is there. So we want to know that this consolidated amount. So DAV said that we have nothing to do with this.
No, that is,
teachers.
they are right. there.
So we take it
NTPC
that
had paid.
NTPC has paid this amount.
NTPC had
Maybe
paid this.
whatever the medium.
That is on the basis of the agreement itself. I was trying to draw your lordship's kind consideration to the clauses of the agreement.
Yes, we'll come to that. We'll come to that. So, and this, now this is important. And the separate set of teachers appointed by DAV College, the society as teachers of DAV, Farakka, and the teachers of DAV Public School, NTPC Farakka, draw the salary as per the norms of DAV Trust.
Yes.
Now, even for the first 2 years, there were 2 teacher in charge working at the same school, one for NTPC High School Bengali, Farakka, and the other as DAV Public School. The present petitioners were under the control of the first one, that is NTPC High School Farakka, and their salaries paid by NTPC. That is why you said that you may be very cautious on what you submitting. And subsequently, after retirement of that teacher in charge, headmaster, the NTPC authority requested the DAV society to give those teachers salary through the DAV teacher in charge, which was run by NTPC High School Bengali Farakka, managed by DAV management. Now, then come to, now this is how this is corroborated. Come to page 625.
There is no denial to this.
No, come to page 625. Now you are claiming one entity. There is a bifurcation. This was by teacher in charge NTPC High School, managed by DAV, not by the principal of DAV, because they are saying there are 2 persons controlling the entire institution. And see the date of
No, but
this, when it was sent.
This is perhaps for a subsequent period.
Yes, this was for a subsequent period.
Where there were no two teacher in charge. Teacher in charge, 2 teachers in charge only for first 2 years.
No, but this is teacher in charge of NTPC High School. They say we have a principal, we don't have any teacher in charge. That is a clear stand of DAV. So NTPC teacher in charge continued for how many years, we don't know.
2 years.
No, they say 2 years, but this is for the year. This must be
2019, 20 like that.
no, this document must be after 2005.
No, this is March after 20.
It is in 2020. No, we do not find the date here.
Date of joining, kindly similar.
No, this date of joining. No. We'll come to that. You see, first person is 89. Second person is 89. Third person is 95. Fourth person is 39. Not 39, 89. 89. So one, two,
last person is 2017.
No, we are omitting that last person. So these persons, at least 1, 2, 3, 4, they were all existing employees of NTPC, not NTPC, the school. And they were all approved. Now it seems they are all being approved.
We have no dispute with regard to the
No,
appointments of teachers and non-teaching staff made by us.
We want to know from you that we are not concerned with any person who was maybe appointed after 2001. When the
By
MOU was,
DAV.
yes.
And in fact, they are not coming here.
No, if the writ petitioners who are there or added respondents who are before us, if they were not falling under those 14 or 4 as appeared from the DLIT inspection report, we are not concerned with any of them.
Exactly.
But so far as the teachers who were there, what would be the situation? Because
that's the only concern.
Yes, because they continue to remain as an employee of NTPC. They receive considered remuneration notwithstanding 2001 MOU. There is no severance of ties between the employer and the employee. They were neither retrenched nor terminated. Their services were not terminated. So what will be the status of these employees More particularly where
Let us proceed on the basis that they are and continue to be
employees of
teachers
of NTPC.
till
Yes.
the school was closed.
Yes, yes,
And who will bear the financial liability?
correct.
That's the question. Now, my lord, with regard to that, I had, my lord, cited judgments to your lordship as to whether their claim is justified.
Now,
The
now
judgment,
NTPC has taken a stand that that is what the NTPC has said, and that is not what we are saying. Come to page 110. Paragraph E onwards.
110.
110 paragraph E onwards.
Paragraph E onwards.
Paragraph.
This is an affidavit of
NTPC. He is the deputy manager HR of NTPC.
May I read out from E?
E onwards, please.
That the name of the respondent company is NTPC and not National Thermal Power, as is alleged. The NTPC Limited is a government of India enterprise engaged in construction of power station and generation of electricity through these power stations throughout India. The NTPC Limited is a government of India company, and section 6 under section 617 of the Companies Act, company has one of its projects at Farakka Superpower Thermal Station. Most of the NTPC super thermal and thermal power stations are located in remote places of the country and far away from town and cities, where education facilities being virtually non-existent in the vicinity. And in order to provide proper educational facilities to the children of NTPC, a scheme regarding the educational facilities for children of NTPC Limited was formulated by the corporation, and a copy of the policy is annexed. In Farakka, NTPC Limited has facilitated 3 schools, namely such and such, affiliated with West Bengal Board of Higher Secondary Education, Bengali medium. The Kendriya Vidyalaya Farakka is run by Kendriya Vidyalaya Sansthan, etc. Farakka is run by Society of Delhi Public School, is run by DAP. In case of NTPC High School, now DAP Public School, all expenditure of recurring nature are made by the school management committee, and any shortfall of recurring nature is made by NTPC Limited as a grant to DPS Farakka and DAP Public School. The audited balance sheet for the last 5 years of NTPC School Limited, now DAV, are annexed. Both these schools are managed by local managing committee of the schools. The NTPC Group General Manager, being the chairman of the state committee, has nominated the working chairman of NTPC High School, now DAV. The principal cum headmaster is the member secretary of the school management committee. A list showing the members of the management committee of NTPC High School is annexed. The state management committee of NTPC High School, now DAV, functions independently of NTPC Limited, and the day-to-day affairs concerning the school are also managed by the school management committee. The operation of the bank account is also done by the members of this committee. In the year 1998, around 38 numbers of teaching and non-teaching staff of the school filed a writ petition.
That is not important. Now you come to.
Then I turn over.
Yes, you.
I come to J at page 114. As is clear from the above referred judgment dated in the above referred petition, the priority sought to be.
That is not a closed chapter. That is a closed chapter.
Then K. In the aforesaid agreement dated 8th November 2001, it was agreed that NTPC High School Bengali Medium shall be renamed, will be known as DAV Public School NTPC Farakka, and all the terms and conditions hereafter set forth. The society agreed to manage the school as a composite co-educational senior secondary school of Bengali medium on public school lines affiliated to West Bengal Board of Secondary Education and West Bengal Council of Higher Secondary Education. It was mentioned in this said agreement that the society will constitute a local management committee.
No, that's fine. That's we stop here. Now, if you come to their page 117, they gave an explanation that for the sake,
of children of NTPC
yes.
Limited, children villagers in the vicinity, the purpose for setting up the school.
Now
R.
Now come to 119 W.
it is submitted that NTPC Limited does not retain any control over the management of DFA public school. Therefore, NTPC Limited is not a necessary proper party. The Honorable Court may please delete.
So this is your case. DAV has said in the affidavit, as you are showing.
But I cannot, my lord, go beyond what was agreed upon. And as per that agreement, I had the obligation to bear the financial expenditure to the extent provided in the agreement. And I had continued to do that.
Now, all the representations when prior to the MOU and even after the MOU are made by on behalf of NTPC. DAV has disclosed letters to show that these are all representations made by teacher in charge of NTPC. So the teacher in charge of NTPC continued. Now, what is the fate of this? Those who were appointed in 89 or 88 and whose approval NTPC had obtained. Although you will find from the composition of the state committee that you did not follow the management rules of 69. And also the government did not take any steps between 92 and 2001. Taking any steps so that it may be derecognized or whatever is there. So NTPC, your chairman, the committee was all constituted by the persons of NTPC. There was no representative from the school. The entire committee was constituted by the NTPC persons.
Initially.
No, it continued till 2001.
Till exactly before the agreement.
Yes.
Yes, that's why I said
Till 2001,
initially.
this aspect was not gone into in the writ petition.
Up to 2001, yes.
But this has not gone into in the earlier writ petition. But be that as it may, that is they have withdrawn the.
So there could be, my lord, guardians representative, teachers representative,
Nothing.
etc.
So this managing committee, for all practical purposes, remain the board of NTPC.
Now, my lord, I will submit this.
Now, and all communications were made for approval, getting all the statutory recommendations.
Everything by the
NTPC.
local management committee, not by NTPC, but maybe your lordships may, your lordships may say that.
It's an alter
But then, my lord, my humble submission is that is it necessary to go into this aspect at all? Because I don't dispute the facts.
No, it is necessary for
I
the
don't
purpose
dispute
of,
the facts.
It is necessary for the purpose of finding out that this is a contract by incorporation. It's a contract by incorporation in the sense that when you give the appointment to them, you have taken upon yourself that you will follow the ROPA rules. So ROPA is a statutory rule. This is incorporated in the service contract. If it is incorporated in the service contract, then it has a different dimension. It cannot be treated as St. Mary's case or any other decision on that, with respect.
My lord, everywhere, my lord, wherever and a school has been recognized by the board, there is a condition that you have to pay salary as per the government rates in all schools. Therefore, all appointments must have been on such lines. All contracts of appointment must have been on these lines in respect of all these schools. The question is, my lord, whether an extra legal condition, which does not apply to me in law.
No, we beg to differ with you. You see, that is why your complexion and texture is important. You are not a Article 30 institution, you are Article 12. With the meaning of Article 12 and instrumental.
I am an Article 12.
So government cannot say I will adopt a discriminatory policy. It was a conscious decision. In fact, when NTPC accepts it, NTPC as a board, it is it's a government company under 617. They cannot take a decision to establish a school and run it without the approval of the government. It is in fact a work executed by the government through NTPC.
Yes, everything.
So,
if I accept entire thing, whatever came from the court, it remains a private school.
Very good.
Private school set up by a public authority. What is a private school? Let us understand that first. A private school is not, my lord, something that a private person has to set up. A private school is one
which is not taking any aid from the government, that's the private school. It may be run by missionary, it may be run by public entities, it may be run by private individuals. But the character of the school remains a private school, a private institution.
Yes.
Therefore, the NTPC school that was set up,
Is a
that
private school.
was a private school, and that continued to remain private school even today. Therefore, my lord, the question is whether such a school is required to comply with the provisions of the ROPA. Although, my lord, such condition was mentioned in the letter of affiliation or recognition by the board. That condition was mentioned in the letter of recognition by the board. The question is whether mention of that in that recognition order will create a statutory liability upon us. I take it, my
After
lord.
9 years, the NTPC would realize that this becomes
Yes,
a
maybe,
burden.
my lord, I might have continued for more. But then question is, my lord, when I come to know that legally,
You have waived your right in any.
does this constitute a waiver? But supposing I had a right to charge something, I have not done that. Does it constitute a waiver?
Depends upon, I cannot have a contract to murder a person.
No, that's it.
So it's a question of that type,
Question-
it's an illegal contract, unlawful contract is not enforceable, but you have a right to contract out from a statute. It is permissible.
It is permissible.
Yes, so if
Yes,
I
no
can
doubt.
contract out of a statute, I have a right to say that I will bind myself to certain statutory obligation, which
My lord, in the
strictly speaking
the
may not
jud-
be applicable to me
judgment I had cited.
as a model employer. I can always do it.
I can always say that I am legally not bound, but still I will pay.
Yes.
I can always do that.
And by
that
that
does not
I
mean
I
that
can say that, because you see this kind of contract has to be treated in a different way than the agreements, the judgments that you have cited.
My lord, waiver is a principle which applies where a known right
Yes.
is is surrendered.
Yes.
When it must be a known right that's surrendered. How do I know when the recognition order is given that this condition is absolutely illegal? How do you know at that moment? Because waiver is always of a known right. It cannot be, my lord, it
You
cannot
mean
be
to say
constituted
that you mean to say NTPC is unaware of its known right when they have given the undertaking?
My lord, NTPC
And after 9 years, they are
My lord,
taking the plea that they were not aware of the ROPA rules.
my lord,
And how did they fix the salary of the
I have
of
cited
this?
I have cited a judgment where,
Yes,
my lord, the market committee,
that's a different issue. Market committee
my lord,
is
they are
not,
all
the facts are distinguishable.
my lord, all facts are distinguishable. No question about it.
Yes.
Any two facts will never tally. But here, my lord, the principle is this: the market committee was going on paying as per the demands raised. I mean, the trader was going on paying as per the demand raised by the market committee for years. Then, my lord, when they came to know that this is not their legal liability, they are not statutorily required to pay this, then they raised this objection. And the court said that the principle of estoppel or waiver doesn't apply.
You cannot realize a fee which you are not authorized in the statute. Is not applicable in this case.
My lord,
It is
here,
not a question of, you see, the taxing statute or revenue statute, these has to be strictly construed and for the benefit of the persons who have been saddled with the liability. So I cannot, the authority under the act, if he is not permitted to realize it, then obviously by picking this, I cannot be made liable because you are lack of authority. Lack of authority is there at the root of it, so it is without jurisdiction. But here it is a volition. I have, I can go to any other, I can have an affiliation for CBSE, but it may not be required. You have the options all over. True.
But then
We'll come back in 5
my lord,
minutes.
after 10 minutes.
5 minutes. You want 10 minutes? Very well, we'll come back.
Okay.
Then may I just take over since Mr. Gupta got engaged otherwise? Well, the point in my humble submission is very limited and very short. First of all, what would be the legal obligation of NTPC to carry on with the teachers as per the payment directed by the government? Now, well, I believe Malasha had been shown the letter of appointments. If not, may I just try to take a look once again. Can you turn to page 56? This is the application which had invited the persons to apply. The NTPC Higher Secondary School Bengali Medium requires the following teaching staff. Which troubles the court and all of us is kindly come to general condition 3. The pay scales for all the categories shall be as per the West Bengal Board of Secondary Education and or rules laid down by the government of West Bengal for aided and recognized non-government school in West Bengal. The other conditions which are completely different that of the conditions which are given to the teachers of other non-government unaided schools. Now kindly turn to page 59. This is the letter of appointment which they have accepted. They will be governed by this letter of appointment, which will be the primary condition of the relationship between the employer and employee. This is the offer of appointment for the test of teacher in physical science. Now kindly see, Lord, that he pleased to offer you the post of teacher, the basic pay of rupees 500 per month in the scale of rupees so and so plus dearness allowance admissible under the rules for the school management.
This rule had never been framed.
Management will not have their own rules, which is definitely mentioned, whether framed or not, but they say they will be guided by this, they knew it.
You offered them a thing without having a rules.
So I will come to that. I will come to that, Lord. But therefore, the clear intention is that you will be guided not by the West Bengal Board of Secondary Education rules. And then 2 says, in addition to basic pay and DA, you shall be entitled to the benefits of contributory provident funds and so and so, and other service benefits which are specifically mentioned. And my lord will find this is peculiar to this letter of appointment, which has nothing to do with other similar unaided schools. This is unaided school, non-government unaided school. And can you see who issues the letter of appointment? Principal and member secretary managing committee. This itself is a clear indication that they have nothing to do with the NTPC as such. The NTPC might have
a managing committee.
Managing committee, school managing committee.
Yes, who are they?
But they are the representatives of the employees of NTPC. Maybe the director or the chairman of the NTPC is also part of the managing committee, but they were not in the capacity of.
Please show us the your composition of the managing committee. Which document?
Managing committee composition work out. Well, I will take a lot more later to found out. Therefore, this is the position as admitted. Now, kindly to make it very short, the problem arose, and the matter was also considered by the government agencies from time to time. What was the response of government agencies? Kindly turn to page 552. This is in volume 3. Not that this is for the first time coming before the court. They had approached the government authorities that they are bound by the assurance they have given. Therefore, state has a liability and responsibility. Now, kindly note, my lord, this is from the government of West Bengal School Education Department. He is writing to the secretary NTPC High School, not again, my lord, managing director, chairman of the NTPC. And what is subject? Representation of teaching and non-teaching staff at NTPC High School regarding payment of salary and appropriate action. Letter number such and such, dated 7th of August 2009, with enclosures received from the Under Secretary to the Government of India, Ministry of Human Resources Development, Department of School Education and Literacy, Shastri Bhavan, addressed to the Secretary School Education Department, Government of West Bengal. Therefore, there was an intervention, my lord, even at the level of the central government, where they thought the NTPC being a the corporation, central government run corporation, therefore they should interfere. Now kindly come to this, very important. I am directed to refer, this letter is being written by Joint Secretary to the Government of West Bengal, to the Secretary of the Managing Committee. I am directed to refer to the above mentioned subject and reference and to state that NTPC High School is a self-financed school. Its admission by the Government of West Bengal. Recognition of the said high school was given inter alia on the basis of the undertaking of the then General Manager that no financial help or assistance from the state government will be required at any time in the form of aid towards running the institution, and scale up in respect of the teaching, non-teaching staff of the state school will be the same as have been introduced by the state government for non-government schools, government-aided schools. Moreover, there was a detailed agreement between the NTPC Farakka and DAB-CMC regarding the function of the school. Under the above background circumstances, there is hardly any scope of intervention of the state government regarding the settlement of the grievances of the teaching and non-teaching staff of the school with the school authority at the present stage. However, I would request you please come to an amicable settlement with the teaching, non-teaching staff of the school regarding payment of fair and better salaries as may be acceptable to them in the interest of the school children. Now, I would submit, Lord, I am bound by the letter of appointment where the salary, what would be paid to them was specifically mentioned. And what that was the condition of Lord granting affiliation at the point of time.
Yes, the managing committee shows.
My lord?
Managing committee.
Managing committee constitution, my lord, I don't find detail of it, but there is some reference. Kindly turn to page 71. Clause B, better copy is at 71A. In compliance with the memo number such and such of West Bengal Board of Secondary Education, the undersigned accompanied with the AI of schools, Malda, made an inquiry to NTPC High School on 8th of April 94. Observations in respect of approval of appointment of the teaching and non-teaching staff are as follows. It appears from the records available in the school office that this institution was recognized as class 8 with effect from 86 and class 10 with effect from 89 and was affiliated to the Higher Secondary Council with effect from 1990. The institution is an unaided one financed by NTPC Farakka. It may be mentioned here that the institution not receive any state government grants in any form. It may be noted here, that B is important, that there is an MC, managing committee consisting of 12 members to supervise the functioning of the institution. But these members are selected by GM HTTC Farakka, designated as chairman of the managing committee institution. Moreover, the GM nominates working chairman and the MC of the institution run under the leadership of this working chairman. The headmaster of the institution is designated as principal cum secretary. It may be mentioned here that the GM of the NTPC, designated as chairman of the managing committee of the institution, is the final authority to take decision in respect of creation of posts and appointments, etc. There are 11 class units approved by the GM NTPC. Therefore, this is the formation that the managing committee run by 12%, all are nominated by the GM. But this institution, as your lordship have been already told, is really an aid to welfare by a public authority to ensure that the employees, students, their wards get education. And for that purpose, whatever the financial assistance necessary, that was provided for. But this is undisputed. I am not troubling my lord with that. Then kindly come to page 72. This is also important. Name of the staff and the date of approval are noted below. Therefore, there are 18 approved staffs.
Practically 14 plus 3 because one had left.
Therefore, I'm
14
giving the
plus-
detailed list for this. Therefore, there are
They are
18 approved staff on that date, and for which we had assured that we shall pay the salary as was decided by the government, and initially it was agreed to and accepted and payment was made. But the question falls for whether, my lord, we are legally bound to go on paying, my lord, the salary as per the ROPA.
What is the present status?
School is closed.
School is closed.
School is closed, but we have also paid. We have paid the teachers who were there, which was their legitimate claim. There is no grievance to that.
14 plus 3 you have paid.
Just a minute. কতজনকে 14 plus 3 ঠিক বলবো তো কোর্টকে yes well, these approved teachers have been paid when the school was closed in 2021 September. Well, the division bench of this court will have found that
21st,
my lord,
on
September 21.
21st September.
Right. September 21. Well, may not kindly note the date, September 20.
The school was closed and all of them, their accounts were settled.
Yes. All of them who were the approved staffs initially, their accounts have been settled. That's my instruction.
But where you have said so in the affidavit shows.
Well, these were developed later. We can put in an affidavit also. When the division bench noted that division bench, there is no student and permitted, you close on the school. The order should show.
Is there any order to that effect?
I believe so.
Which order can you please tell us?
Exact order date mone ache?
Oh, yes, yes. It is an order of 5th October 2021, it seems. Maybe so. Order a copy of order a copy. Order.
Order sheet को नहीं सकते তোমার কাছে আছে সময় তোমার কাছে অর্ডার কখন আছে
ক্যান 10 এর এক্সট্রা আছে ক্যান 10 যেটা কিছু আমাদের
24th March. They held by a copy of this order, my lord.
আমাকে দাও না দেখে নিই
So 21st January 2021.
The 21st March,
21st January 2021.
Maybe so. Which order to work on 21st January?
Now,
Yes. No, my lord is right, my lord. The order directed to close down is at page.
no application.
This is on 21st of January, 22nd of January. May I read out the order? We
Very
are
well.
told that
So,
at present there are 35 students in the
Mr.
school.
Bhattacharya, just one thing, that, Mr. Gupta assured the court that the salary arrears and other dues of the teachers payable on their separation of the school on the closure shall be paid by his client according to their interpretation of the applicable.
Those who
rules.
are paid blood to the writ petitioners who are before the court in the writ petition. Thereafter, all these applications have come.
No,
There are initially five writ petitioners who are before the court. And
So-
on their writ petition, this order was passed and they have been paid.
Yes, they have been paid this amount. Now, they are the writ petitioners also. They are the writ petitioners.
They are the writ petitioners.
Now, after this order, after they receive payment, you have any grievance to that?
They are not before the court now.
My lord, may I just,
Who is the writ petitioner?
The writ petitioners but have got their benefit and
Dr. Tejnaran Singh Tarun. You are Dr. Tejnaran Singh Tarun.
my lord,
Yes, yes. We are.
No. Mr. Bhattacharya, the writ petitions was filed. Then in the appeal, on the basis of the submission made by Mr. Gupta, that the salary arrears and other dues of the teachers payable on their separation from the school on its closure shall be paid by his client according to the interpretation of the applicable rules. We direct that 50% of the arrears part of the package be paid by NTPC Limited to the 5 respondents by 31st March.
yes.
The balance shall be paid at or before the closure of the school.
Therefore, that was carried out. So for the 5 are concerned, there is no grievance.
So 50% also being paid.
Yes, that was also
After closure,
total. The order only total the payment.
so after closure also you have paid.
That's
After closure.
till the date of closure.
No. He said
yes,
balance shall be paid at or before closure of the school.
That has been paid.
After closure, it has been paid. So entire 100% has been paid.
5. So for the 5 respondents, as was mentioned,
No,
my lord.
Mr. Banerjee is present that those 5. Those 5.
yes. My lord, just 1 minute. I file very rightly, my lord, put these questions.
That was placed.
Just,
Now
just,
they are-
Mr. Bhattacharya, just a minute.
No, we want to know whether the
Now,
No. Section, my lord, we have filed an application, can 10, which is still pending. Not that entire amount is paid.
entire amount in
in
terms of this order.
Huh? In terms of the
Certain amount has been paid.
entire amount in terms of this order.
In terms of this order,
In terms of the order of 21st January 2021.
this order, not that the entire amount has been paid. Yes, that has been paid.
In terms of 22nd January 2021 order, 50% of the amount to be paid to you now, and after closure, balance 50%. Have you received that amount or not?
My lord, as the assets, that is very vital
Yes,
aspect.
as the assets.
Yes, that's the asset.
It has been paid.
My lord, so for the closer, you have also paid. That amount has been paid.
Entered the amount. Very well.
I cannot deny that,
So now
but
the-
as the assets,
Their grievances, they are entitled to get as per the change of ROPA rules and in terms of the ROPA rules, which we contest. We say that when given appointment, we did not say that we shall go on paying as per the ROPA rules whenever it comes. And in private schools, your lordship is well aware, there is a Supreme Court judgment also that the government pays out of the public fund. It is not feasible for the private schools to pay always. But we have paid in terms of the undertaking given, and that's my submission, my lord. When we gave the undertaking, what was available there, we have paid it.
Now, but the added respondents who are here, we were amongst this 14 and 3.
The added respondents are about total. Yes, my instruction, my lord, that they have been also be paid in terms of the letter of appointment.
So, if you have paid this to them, because they were all under the GNHT inspection, they were all there.
Yes.
So similar benefit should also be extended to them. Similar benefit should also be extended to them.
না না তোষাদ যেটা বলছেন যে পেশনাদের বেনিফিটটা দেয়া হয়েছে তাহলে যারা সেই সময় ডিএলইটি রিপোর্টে ছিল তাদের সবাইকে
How it could be discriminated?
No, like my instructions they did confusing. But
Because they cannot be.
no,
treated
I
differently.
follow that court's view,
Yes.
which is quite reasonable also to me. But
Yes.
the instruction
I would have
which-
followed that 2000, post 2001, no.
No.
But prior to 2001, if they were there,
if we have paid in terms of the order of the court, why should we
yes,
not
there
pay
is
to the
kind of
others?
inequality.
না সেটা তো তাহলে সেই ইনস্ট্রাকশনটা নাও সেই ইনস্ট্রাকশন নাইলে হবে না তো that is necessary.
Yes.
No, I don't want to waste court's time on this, but if it is not on that, I have to take instruction, come forward. And as an NTPC, Lord, I have no hesitation to say that we cannot, Lord, play like absolutely, Lord, an employer on the street. We cannot. That's true. But that must be on the basis of the reasonable and the letter of appointment. So that I cannot be compelled to go on paying, Lord, in the rules, ROPA rules from time to time. We have paid up to ROPA rules of 1998. 1990. We have paid up to Lord ROPA rules 1990. That's my instruction. But this is the short point.
But have you seen the order of admission? We are for the first time seeing it. See the order of 22nd January 2020.
Must be that subject result of the appeal.
No. See the observation. We are for the first time looking at this order.
21st January. 22nd January.
2020, 22nd January, I'm sorry. No, not that. See the second page of the order. Mr. Mukherjee is presently unable to inform the status. That is the state government.
Mr. Mukherjee, advocate of the state, assures this court that state government will provide all assistance to relocate the 5 students in neighboring schools. That is about the students.
No, not that. It starts with Mr. Mukherjee is presently unable to inform us the status of the proceeding before the commission. Have you got this order?
No, this is 22nd January.
22nd January 2020. এটা দেখো এটা
2020. What are going to
please look at from Mr. Mukherjee. I just put a tick to it.
Second page বলছেন
2020. 22nd January 2020. এটা 21 দেখাচ্ছে তুমি আমাকে। Mukherjee is presently unable to inform us the status of proceeding before the commissioner and has paid 2 weeks' time to return the better instruction. Well, that
please read the
from the
remaining part.
recognition granted to the NTPC High School, this and so. The salary presently school has not more than 10 students as we are informed. As in the record in our earlier order dated so and so, the actions of the appellant are not overboard. In view of the fact that the recognition was granted on certain conditions, the respondent petitioner's prima facie entitled to claim that such conditions ought to be complied with by the NTPC. Yes, that's the argument now.
So this was the observation at the time of admission. This we are seeing is for the first time.
তাই তো বলছেন অ্যাডমিশনের সময়।
That is why there's a yes. So today is basically the financial part of it. So as on the date of closure, whether they will be getting the differential amount of what you have calculated on without ROPA, you may have calculated on the basis of your own thing, and if you go by ROPA, then they will have different scale of.
That's the only thing that to be considered. Whether the ROPA from changing character from time to because of pay commission report. Now the government is fighting the Supreme Court that even the DA is not payable.
That's a different.
I say no, not nothing to do with this case, but that's an instance.
That DA has a different connotation than.
No, under the ROPA, DA is a part of pay. That's why the division bench will not allow that prayer, and the review was also dismissed.
No, we have discussed it in, of course, in the context of Electricity Commission, which came up before us in appeal from the tribunal read. There is also the DA concept, but it will be paid similar clause, not less favorable than what they were enjoying before their takeover. So the issue arose that after the takeover, because when it's a statutory corporation, by a statute when they were taken over, they had a separate ROPA rules made for them. And that separate ROPA rules provide that they shall not receiving amount of salary, DA, whatever, which is not less favorable to them as they were enjoying at the central government rate at the time of takeover.
Therefore, that's the date. That's the terminal date. That's the point.
So if they were enjoying at the time of takeover, the central government rate, you cannot deny that. That is a point which came to the tribunal and matter ultimately came to us. So we said in our judgment that if this you are bound by contract. The ROPA is a statutory force. So once you have agreed to this, when you constitute this ROPA rules after the takeover, and the employees had having agreed to have their service transferred to this, you cannot say that you will not be obliged to pay the DA at the said rate. And we made a distinction between basic salary and other things. And of course, we say with the rider that DA cannot be equated as a basic salary. And if there are conditions which said if they are demonstrated to the court may in appropriate situation refuse. That's we say.
That's the proper interpretation. Now, that here, that's why I was trying to insist upon the letter of appointment is the condition. The letter of appointment doesn't say that with the change of ROPA, your salary would be changed. No. We are given a particular scale, grade scale, and you are entitled to get the increments in terms of the scale. Had it been stated that your salary would be governed by the ROPA rules, that would have been a different situation. The letter of appointment is very important.
There are two things. Even in Mr. Bhattacharya will be much more aware than any one of us. Even the latest Supreme Court judgment, I think, authored by Justice Bela Trivedi in 2018 or 19. And we have also referred to in our judgment. Salary and DA. DA is now part of salary. We said that if the financial condition of the organization does not permit payment of DA at such rate, at the central government rate, we are not, because DA, as you know, is because of the inflation. To absorb
as
the
per
inflation.
the CPI, cost of price index.
Yes, price index. So it's just to give you a cushion. More in the nature of adjustment because of the inflation. So we said that, well, the rate of DA or how much you will pay for the DA is a matter which may depend upon the financial condition. That's why we called for an affidavit. And we asked the organization to file an affidavit to show that your financial ability or inability. And on that factually aspect, we took note of that in the judgment. And we said the financial situation is not that bad or not such which may deprive these petitioners for receiving the DA. So this is one aspect. Suppose I am in the process of being referred to IBC. So I may not be compelled to pay a sum which may be under the contract, but well, I am obliged to pay the basic salary. So that is one part of it, but this is not the issue here. None of the NTPC has not said that this is, look at my balance sheet, I am not in a position to bear this expense. This is not there, does not come on record. So the question is this, that if you have agreed to pay a particular amount and you have having agreed and having paid it, I think you have paid it up to 1998 or 99. Then thereafter you started paying, you have paid the salary. I'm sure you have paid the salary, but not at the rate of ROPA 1999. You have ROPA 1998 and 2009. These two ROPA. Then what would be the consequence of it? And you have paid it, they have accepted, and after 2001 you started paying them less, and then they started complaining about it. This is the position, and you are a government organization, so you cannot take the stand of a private body.
Well, I will not join issue there.
Yes.
Because the role of the government organization cannot be equated to the role of a private individual or private trust.
That be so.
Now, but here, what was my obligation? That my initial obligation was that I will fund you so far the recurring deficit is concerned. And that was known to everybody. NTPC said, yes, for the wards of my employees, You run a school. I will provide you infrastructure.
No, but after 2001, for these petitioners who had paid this, NTPC had not provided any funds for that. And how their salaries are being determined after 2001?
Whatever shortfall.
No, we want to know from you is very important. After 2001, what is any fresh appointment letter issued to them?
No.
So they were continuing under the, so not in clause 6. So clause 6 was not implemented. So clause
They are
6
continuing with the private management of under
no,
the
but
NTPC.
clause 6 has a different connotation. So clause 6 was not implemented. So they remain continued to be in the employment, whatever nature be there. And
forget about the DAVP. I am not on that. But the question is
no,
not.
I'm saying the DAV, you see, under the takeover code, whatever you have, clause 6 contemplates two situations. Either they continue to be the liability of NTPC, or once they are taking the options, or they have been given an option. So admittedly, as Mr. Gupta has said, that they have not given its option, their services are continuing. So their services continued till the school was closed. Now NTPC has a different representation and DAV has a different representation in the school. DAV in the affidavit has said that we are taking care of those teachers who were appointed by us after we take over. So there are two classes of teachers operating in the same school from 2001 onwards. Factually, it appears to be so, not denied by anyone. Now, question is this, that after 2001, how their salaries are being paid and who are paying their salaries?
After 2001, the same system which was prevailed prior thereto, that the payment is made by the management committee. Management committee.
That management committee, see, that management committee supposed to be now, the present management committee is now replaced by the local management committee. That is what the takeover contemplates.
Now the taking over.
5:4.
Because the taking over now has not been implemented so for the persons who did not opt for going to DAV. The persons who remained, they remained with their old condition. Then the question of
if they remain with the old conditions, then they have a right to receive. You see, their service conditions have not been altered. If their service conditions are not, there are two sets of different service conditions. See the peculiar situation. There are two kinds of service conditions existing in the institute. One service condition governed by the initial appointment letter, which was not terminated. I would have followed in 2001, you say, it is possible that when I take over, then with you have a cessation of employment, with a fresh term, then possibly a dispute could have arisen in 2001 itself. The other thing to say that you will continue to remain in the organization and abide by the original letter of appointment. Now, this original appointment letter, if it gives certain benefits to them, that benefits whoever is there in the present management committee, because you see the DAV is trying to shrug off their responsibility by saying that they are not our staff, so we will not carry on in
future. Kindly forget about DAV.
So
that
you continue to remain as
they continue to remain under the employment of the management committee. That the management committee was not being assisted by the NTPC out of its fund, so far the shortfall is concerned. But the basic thing remains that the NTPC has no obligation vis-a-vis the employees, except the undertaking which they have given. And what is the impact of the undertaking? That this court has to decide with the greatest of respect. The effect of undertaking is that the affiliation of the school depends on this. You will pay the salary of the teachers as per the government unaided teachers. But that was at the time of getting affiliation. But that does not say that I have to continue to go on paying with the change of the salary as per the RUPA rules. That is the big point. If I am governed by undertaking is valid on the date of getting affiliation, I have paid. And the board did not come forward and say that your affiliation is withdrawn. Yeah. But if I cannot pay, if I do not pay, what is the effect, consequences, the affiliation goes? Now, there has been no consequential act on the part of the West Bengal Board of Secondary Education. Affiliation continued, and affiliation continued not knowing that the salary is being paid. That's why at the government level, they say, this is a matter between you two, you can settle it amicably. There is no compulsion. But why do I will not rely on this letter? Because this is not communication between the two government departments and the board. They do not say, no, this is not mandatorily applicable. Negotiate it. But if your lordship will not gives any importance to that letter, which in Muhammad's submission is very important to be relied upon, then it remains without whatever the financial situation as was prevailed on that date would be followed, that we are following. We have no difficulty in following that. But we have paid up to 1992 ropa, 1990 ropa, we have no difficulty in paying that. But lordship, if they say, no, we are entitled to get that, which was denied by both the government. The undertaking arose because of affiliation, nothing else.
No, it was denied in the sense that they say we will not take it over. State government says we are not
taking
going to
over
take
is
the
different. State government
State
says
government cannot say. State government ought to have said something on that time, but they have not possibly recognized you because that will cause prejudice to the teachers and the students who have functioned.
no, they could have said. No, that was no, that's a warning that if you do not pay, the affiliation will be withdrawn. Then the decision would have come at that point of time. The authority will not, knowing full well, having full knowledge of it, will not.
No, but can it anywhere to your benefit by the state not responding to that request?
No, no, I am not
acceding to that request.
No, I have nothing.
You are bound by a contract.
I am bound by the contract as the teachers are bound by the contract.
Yes, both of you are bound by
the contract depends on the letter of appointment.
Yes.
Lordship, if
letter of appointment, first clause, please read the letter of appointment, first clause.
Kindly come to that once again. The basic pay of rupees 500 per month in the scale of so and so plus DNS allowance. Page 59.
No, I'm sorry. Please read it with the advertisement.
But advertisement says so.
First clause.
Yes, advertisement says so, but not when advertisement is not the not contract.
No, it's a representation. It binds you.
On the basis of which I offer him.
And this letter of appointment is no way diluting the clauses in the advertisement.
But with deepest of respect, I would submit, my lord, the advertisement will not invite applications for selection, and when the offer goes, my lord, the offer is page 59.
No, you are
pleased to offer to the post of so and so. But he had the option to
please
not
see the advertisement. Please see the advertisement.
The advertisement is at page 58. Clause 1. Scale of pay as per rules framed by the West Bengal board, by West Bengal government for such schools. For such school, there has been no rules framed by the government of West Bengal for unaided institutions.
For different, you said page 52, page 50?
58.
58, yes.
56. 58.
Yes, 58. Scale of, this is your advertisement. Applications are invited for the following posts.
Yes.
When you make an application, you also give the terms. So once I accept it, a contract is concluded.
No, I
it's an offer and acceptance.
That this is very finer without difference. That this is without an offer to invite application for selection.
Yes, but on these terms.
Yes, not when he's selected, then I offer him for the post. Because lordship is well aware, because the advertisement conditions may vary with the letter of appointment. In many cases, you have found that these are the.
Is there any variation to that effect?
Yes, kindly come to page 59.
Yes.
This is offer of appointment to the teacher in physical science so and so. The basic pay of rupees 500 per month in the scale of rupees 500 so and so, plus DNS allowance admissible under the rules of the school management. Clear departure. Though you have been offered the post mentioned above, the management reserves the right to engage you for taking such classes, subject as considered suitable according to the exigencies. Therefore, this offer, my lord, if this binds me under the contract, my lord, I have complied with this. And if there is shortfall, I am approving.
You have concluded your submission, or you? No, you have concluded your submission.
Yes, ma'am, that's my submission.
So,
Next time may be fixed, my lord.
So we have heard last time whom we have heard. Yes, Partha Shardi Bhattacharya, yes, we have heard. Take now.
এই নেক্সট দিন বলবো দেখা কিছু আগের দিন টাইম নিল
At the time of
7 দিন জায়গায় গেছে না জানি আমি ভীষণ ক্ষতি করে দেয় ভাইটা
ask for clarification.
একদিন তুমি এলাম বলবেন সেদিন 16 তারিখে তো ফিক্সড হলো
Next week, next Wednesday.
Next Wednesday.
With a party.
পরে দেখা যাচ্ছে
ষোলো করেছেন না 17? এই 17 করলে আপত্তি আছে?
না বল তাড়াতাড়ি
Could it be on 17th?
Next week.
Could it be on 17th?
I don't have any objection.
17th is Thursday.
17th is Thursday.
Very well, I don't have any objection.
Very well, 17th.
17th.
Then 17th we keep it at 2 p.m. to be other place.
So they have finished the argument, now we will, our turn, we will start.
তোমাদের শেষ হয়ে গেছে?
তোমাদের শেষ হয়ে গেছে। No problem, we will come back on 17th. 2 p.m.
17th 2 p.m. বেঁধে দাও এই তোমার কি আছে কোনটাতে বলো এইটা চেম্বারে
Madam, for that.
Last order টা বলো তো?
Madam, last occasion,
Yes, where is Mr. Banerjee? Yes. Yes.
রিটিং ইনস্ট্রাকশন কপি কি দেবে? সব তোমাদের ফেভারেবল যাওয়া কপি চাই।
Then again, it's a mistake.
My lord,
20,202. Without portal, you made a correct. Without portal.
mistake, madam, my lord. Praying, my lord, unconditional apology, my lord.
Stay down.
My lord, in view of this, my lord, instruction, your lordship, my lord, they has to call my lord in the interview. My lord, in the interview, my lord, if they get the number of the last panel candidate higher number than the last
Please
panel
a call for interview.
he will be, my lord. In accordance with law, my lord, he will be, my lord.
The written instruction.
In the way of, my lord, any candidate, my lord, if we, my lord,
That should have been considered by trial court itself. Why this point?
this was, my lord,
my lord, may I pray one thing, your lord, if your lordship kindly fix some time, my lord.
Recruitment process, we cannot say the time.
it is over, my lord, we will not, my lord, it will be, my lord,
Yeah,
immediate.
give a direction.
Let-
Next appeal application disposed of. Next. Next matter, Daku. Yes.
the state in this matter? In this matter, my lord, I am on behalf of the respondent number 4. In the last occasion, I have
This for
filed
the
an
petitioner.
application.
And whose instance this has been listed, but I don't know. No notice has been served subsequently.
Notice has been served. This is a copy of affidavit.
No, who are you?
I am on behalf of the respondent number 4. Respondent number 4, my lord.
At whose instance the matter has come?
The matter has come according to my submission in last occasion. I have submitted that I have filed an CAN application, my lord, and my salary has been stayed since June 2023. This is a copy of the
And this is the last order, my lord.
My lord, my application is just to modify the last order,
Yes,
my
yes,
lord's
kindly see
order.
the last order.
Just a minute.
My lord, the appellant, my lord.
Absolutely correct.
My lord, respondent number 4 is present, my lord, before this court, my
What
lord.
will do? Respond number 4. She was cooperating all throughout and now she is present.
She didn't do any kind of non-cooperation with this appellant because the personal no enmity is there.
We know of this. How
My
it
lord,
happens
I am
in
the present
how
teacher
this
in
nasty
charge.
politics happen in school.
My lord, I
Nasty
am the,
politics now that she is now it is pricking her. That is why he's here.
my lord, kindly see just 2 annexures, my lord. 2
What
annexures,
is
my
the
lord.
why the appeal is? Who is for the appeal?
Appellant advocate has, clerk has informed me that he is just within the chamber and outside and he cannot come.
No liability
Right now.
certificate. They have, the first court has rejected on the ground that since no liability certificate has not been there. And
So no liability certificate has to be issued by the school.
School.
So
My lord, where is my impediment? I want to see just only 2 annexures,
you
my
don't
lord.
want to see any impediment. You cooperate and we'll release your
My lord,
salary.
kindly direct me. My lord, kindly regularize my salary. That is
No,
my
will not.
submission.
Unless you comply with this direction, you are
My
cooperating.
lord,
you will
there was
not.
no such direction upon me to issue a non-liability certificate, my lord.
Who are you? You are the teacher in charge.
I am the teacher in charge, my
So
lord.
what you are expected to do?
Sir, expecting to
What
do,
is you are expected to do? Please tell us.
sir, expecting to do,
What do you say of this? Your salary for rest of your life will not be ever released.
my lord, kindly see 2 annexures.
Whatever you are required to do, you issue this. Then only we'll consider your.
My lord, kindly direct my client, that is respondent number 4,
Why
to,
she requires a direction? Why she has not cooperated?
she has cooperated, my lord.
Why
My
she
lord,
has not-
kindly
why
see
she
the
has not-
annexure. My lord, kindly see annexure P. That is,
the copy may be given to me, my lord. I don't have any copy of this
This
application.
application is for
Any copy.
modification. It's nothing to do with this.
my lord, kindly see this annexure, that is annexure P2. This is the statement of discharging the liability at the time of retirement. My lord, kindly come to page 16.
Yes.
My
There is a
lord.
requirement. There is a requirement.
My lord, kindly come to page 16. That is bottom, the appellant herself has signed this document, my lord. Kindly come to page 16, that annexure P2, that has not been annexed in the appeal. And according to that, my lord,
See, by the order,
my lord,
why the division bench has done it. The division bench directed the teacher in charge, headmaster,
my lord, kindly see,
to
just only
be
2
personally
annexures I
present
want to see.
to assess this code on the next date.
My lord.
This is the order of 16 July.
My lord, that explanation has been given in annexure P6
21st.
and P7, my lord. I was in heat stroke, my lord. I couldn't come. My doctor certificate and the attendance registers of my school, I couldn't able to go to the school on that day also. My lord, kindly condone my absence. Kindly condone why did I
Mr.
couldn't?
John Mithro. In his absence, we cannot pass any order.
Lord, kindly pass over this matter, my lord. I want to see only 2 annexures. Why I couldn't give? I want to give this. There was no question of enmity between me and appellant. Kindly see, my lord.
Where
2
is your-
annexures I want to see.
Where is the order? What is your instruction?
So far my instruction is concerned, my lord, the order has been complied with this much. Except that, nothing, my lord.
My lord, kindly see annexure
My lord,
page
in the
16.
impugned order, my lord,
So we have seen that
the
she has
bill
not
voucher,
submitted
there are disputes with regard to some bill and vouchers amounting 80,000 and odds.
That is
That's
why.
why, my lord, this no liability certificate has not been given to the petitioner, and my lord,
My lord, there was the office.
The attested photocopy of the bills, vouchers.
Produce the self-attested copies of the voucher, statement, expenditure, school authority within 7 working days from the date of receipt of the said order. After receiving the same, the school authority would consider such attested photocopy
My lord, there
vouchers
is,
as original, because his claim is that original has missing.
my lord,
What
the
is the
pension
reason of the-
provident fund director has been directed upon the appellant to serve the original receipt that he has given, the appellant has given the expenditures vouchers of rupees 80,650 to the director of the
But
pension
appearing-
provident fund.
Lordship, I'm for the appellant.
Why you have not submitted those
My lord,
documents?
at the
original?
initial stage, when I retired, my lord, there was no allegation. She gave a letter that you declared that no court case is pending against you, then the no liability will be issued, my lord. So I gave the declaration. I filed the first petition that was disposed of with the direction upon me to give a representation, and on the basis of the representation, director of pension provident fund will take a decision. At the time of recent hearing, my lord,
No, what was your capacity? In what capacity you worked?
I was the headmistress,
You were the headmistress.
lordship.
So
And after
now-
retirement, my lord,
So the director directed the petitioner to produce self-attested photocopy of bills, vouchers, and statement of expenditure to the school authority within 7 working days from the date of receipt of this order, and after receiving the same, the school authority would consider such attested photocopy. Now, these bill vouchers
My lord,
were during your time.
no, my lord. After retirement, this allegation has been made, my lord. So I am not the custodian of records, my lord, and I am not holding the bills and vouchers. Bills and
you have
vouchers
allowed-
at the time of
this reply is page 16, my lord. I am the custodian of the record, whichever she has discharged me at the time of
So
her,
when you take over,
my lord.
these documents were in order, or
This is the copy, my
no,
lord.
no, you must have on basis of this,
My lord.
you must have allowed her to allowed her to issue the no liability certificate. Then why you now after the fag, after she was discharged or everything, why you are required this?
My lord, kindly see page P annexure 2, P2, that is page 16. That is at the time of handing over the charges, what I have taken into my account, all the records, for which I am at present the custodian.
Page?
Annexure P2, page 13 of my application, my lord.
কোথায় অ্যাপ্লিকেশনটা না অ্যাপ্লিকেশনটা কোথায়?
P2. That is the handing over of charges of the entire document has been listed.
Correct.
At the 16 page, kindly come lordship at page 16.
Yes.
At the bottom of this, there is a point that 2-1-2020 থেকে 18-1-2020 পর্যন্ত, my lord, may I continue?
Yes.
বিদ্যালয়ের ছাত্রছাত্রীদের বার্ষিক ফি বাবদ 80,650 টাকা অনুসারে জমা পড়েছিল, এর মধ্যে কেবলমাত্র 3,619 টাকা ব্যাংকে জমা পড়ে। বাকি টাকা প্রাক্তন প্রধান শিক্ষিকা শ্রীমতী ঝিলকা ব্যানার্জি, দ্য প্রেজেন্ট অ্যাপিলেন্ট হিয়ারিং, নিজ সিদ্ধান্তে খরচ করেন এবং টিচার ইন চার্জের কাছে ব্যয়িত এই খরচ তিনি উল্লেখ করেননি। This has been signed by the appellant herself. The middle portion is the signature of the appellant. My lord, that year the audit, I have an impediment in questionable for the audit report, so that I couldn't issue on that particular day the discharge certificate, no liability certificate.
জরুরি পরিস্থিতিতে
জরুরি পরিস্থিতিতে নিজ সিদ্ধান্তে, according to her own decision,
না জরুরি পরিস্থিতিতে
খরচ করেন
what is কি না থাকায়
এবং টিচার ইন চার্জ শ্রীমতী ঝিলকা ব্যানার্জি নিজ সিদ্ধান্ত,
where you say that where she has signed.
sign the middle portion. This is Jilka Banerjee, the middle signature. The right hand is my signature and the middle signature is the appellant signature.
Yes.
She has admitted that she couldn't give.
জরুরি পরিস্থিতিতে what is না থাকা APDT, what is that?
My lord?
APDT নাকি APDO, what is that না থাকায়? No, you see the endorsement at the on the left margin, left margin. জরুরি পরিস্থিতিতে
President most probably, president না থাকা।
President না থাকায়।
That was my impediment to not issue knowledge certificate.
My lord, president was died, my lord, at that point of time. So for the smooth running of
So that is why you have, that is why you must, you must say
the
that
bill-
these payments, you have to vouch for these payments. What is wrong with
All
that?
vouchers are there in the school, my lord.
So
She
you
is
have to
denying,
vouch-
my
You
lord.
have to vouch for that, these expenses
Yes,
you incurred, that you have to vouch for it, that's all.
I have given the statement, my lord. Kindly come to page number 31 of my 1 of my application, my lord. Can 1.
This is not the voucher and receipt, my lord. This is a statement.
Detailed statement I have given.
This is not the statement.
That's it.
The vouchers will be produced before you, you self-attest it, finish. In terms of this, you get your salary.
My lord, vouchers I have given before the DPPG, my lord. I have deposited. Then again she is asking, my lord.
No.
And it is recorded, my lord.
No, it was not deposited.
Not deposited,
My
that
lord,
is
every
voucher.
time.
These vouchers, they will produce to you.
Lordship.
These vouchers are with you. These vouchers are with you.
Lordship.
No, not with me.
Then with whom?
That is under the, that has not been deposited by the appellant, my lord. That is the my impediment to not to issue notability certificate.
শিক্ষিকা
She couldn't produce, my lord.
ব্যতীত খরচ তিনি উল্লেখ করেননি।
করেননি। 3,619 টাকা ব্যাংকে জমা পড়ে। That is with me. And বাকি টাকা প্রাক্তন শিক্ষিকা শ্রীমতী ঝিলকা ব্যানার্জি নিজ সিদ্ধান্তে খরচ করেন। টিচার ইনচার্জের কাছে ব্যয়িত খরচ তিনি উল্লেখ করেননি। That is corroborated by the, my lord.
You did not get the account for the balance amount of 80,650 when she was the teacher in charge.
She was discharging at that, this is the date of her discharging
So you
teacher
have
in
signed
charge.
it. So onus is on you. Have you disclosed this document in your writ petition?
Yes, my lord. All the documents
No,
with
this
the
you have
custody of the
disclosed.
school, my lord. My lord, if
If you have disclosed or not, we ask you a simple question.
disclosed, my lord, they are denying.
Where?
They are denying, my lord.
No, this document.
এই ডকুমেন্টে অ্যাপিলে
Yes, my lord. Documents have been.
Your writ petition, have you annexed this document?
No, my lord.
So here you have admitted that বাকি টাকা প্রাক্তন প্রধান শিক্ষিকা শ্রীমতী ঝিলিকা ব্যানার্জি নিজ সিদ্ধান্তে খরচ করেন। So according to
I am
you-
not denying that we have not expended, my lord.
So if you have expended, they want on what heads you have expended.
Yes, my lord. That explanation is given
Where,
in page
where?
page number 31, my lord. That's the statement, full statement I have
Page
given.
31.
Page number 31 of the application, my lord.
application.
Can number 1, my lord.
Page 31.
Page 31, my lord.
Yes.
The details I have given, my lord.
Pay, yes, pay is there. So he has given a Nurarian company.
Full statement I have given.
This is not the original bills and voucher, my lord.
You can always re-verify from them whether they have
My
received or
lord,
not.
kindly see the order of
You can
the,
always re-verify it, madam.
I don't have it, then how can I re-verify, my lord?
WPSCDL, they have given receipt number. You can always
My lord,
write to them.
kindly see the order
You
of,
can always write to them and find out whether they have received the amount or not.
that has not been submitted to me, my lord.
These breakup of expenditure, who has given?
Breakup of expenditure not given to me, my lord.
This document, you are aware of this document or not?
I'm aware of this document
You are
after
aware of this
receiving.
document. Why the present incumbent cannot find out from the?
Because the originals is not with me.
Doesn't matter. Ask them. These are all your employees, whether they have received this amount or not. Are they not your employees?
Yes, my
So
lord.
you are beating around the bush.
My lord, the impediment was in,
There is no impediment, madam. Absolutely, there is no impediment.
my lord, there was a director pension provision.
You can always write to them that this is the receipt number, please verify. And you see denying that there was no disconnection of electricity.
My lord.
And she will carry the electricity bill.
My lord, kindly see
I'm deeply oppressed.
in the hearing of the director of the pension
And
provision
audit
fund,
fee, is he not your auditor?
that has been audited.
Then
That year,
this amounts are for auditor. Can you not find out from the auditor these amounts have been received or not?
My lord,
What you are saying?
my lord, at present, I
will not release it. Will not release it till this matter is resolved by at your end.
my lord, at present.
Sorry, no.
My lord, at present, my lord, kindly see.
Sorry, no.
My lord, kindly see why I couldn't give, my
Not
lord.
discharging her duties.
My lord, kindly see, that is director pension provision from group insurance, that is page number 10, my lord.
He will re-verify this and certify this.
My lord, that has not been submitted.
You have to certify this, madam, if you want to get your salary.
My lord, kindly regularize my salary.
No. You first certify this. These are all in your record. You cannot say this is absolutely a frivolous thing that you have filed. We will dismiss your application with exemplary costs.
My lord, kindly regularize my salary,
No,
my
absolutely
lord.
not.
Because
absolutely not, madam.
Because there was
compel us to dismiss with the exemplary costs.
My lord, her salary, my lord, kindly see just one page, my lord.
This is all in your record. You are not disputing that there was a disconnection. You are not disputing that S. Nuradi is your auditor. You are not disputing that these persons are your employees.
My lord, kindly see why she is not getting her pension, not because of my fault. My lord, kindly see.
What is
This is the last annex I want to see. That is annexure P1 of my application.
Yes.
This is the order of the Director of Pension Provident and Group Insurance. He said that, my lord, that the appellant did not submit the original group vouchers of the 80,006.
This must be with you. This must be in your
That is not with me. She has not able to see the receipt also,
How
my
she
lord.
will carry this? Have you verified from these persons that they have received this amount or not?
My lord,
It's a
that
matter of
has-
2 minutes. These persons, if they are not paid their salaries, they will gherav you.
My lord, at present, my teacher in charge is present before with the no liability certificate, my lord. But kindly give me a direction, my lord. I want to hand over it to as per my lord directions. And just
Conduct is not at all good, madam.
my lord, kindly
Absolutely not,
condone.
because these are all re-verifiable.
My lord, kindly condone.
These are all re-verifiable.
My lord,
Why
kindly
should we
condone.
condone it? We'll impose cost on you.
My lord, kindly condone because my lord.
Take down.
May I take on a sleep note? One matter is going.
To my lord.
On consideration. To pay first and lose.
My lord, kindly regularize my
Sorry,
salary,
no.
my lord. I shall
Wanted
extend
to pay first
altogether.
and we don't. She should have come and apologized and surrendered.
Sir, kindly
No,
my
no. She should not play first and lose with the court. We don't approve of this.
my lord.
We don't approve of this. Ki bollam? Should we condone her? You have created trouble for her for last 3 years. Why should we condone you?
There was no order of Director of Pension Provident Fund.
You could have re-verified and said that I am re-verifying it. Please release her pension.
My lord, appellant could be contacted me.
Bolo.
Value of pension, I have only received the provident fund money.
Gratuity you have not received.
No.
Gratuity and what you have not received?
And commuted value of pension. Pension.
Pension shall be released.
Issued, my lord.
To
কি বলছেন?
কোথায় আটকে গেলেন আপনি? অর্ডার যখন হয়ে
Why
গেল।
do you stop?
My lord, only because of no liability certificate after pension payment order.
My lord,
With that, it has to deposit there.
Pension Provident Fund.
salary attached? Where is you file an affidavit? You said you have attached the salary. You file a report. Where is the report?
Use my lord. Respondent.
ওনাকে
No,
জিজ্ঞেস
no.
করছে
State
কমপ্লেন
is
স্যালারি
state
স্টপ
has
করে দিন তার
complied with the
কমপ্লেন
order.
রিপোর্টটা দিন স্যালারি স্টপ
Mr.
হয়ে গেছে
Basu Malik said that we have complied with the order. Where is that order?
স্যালারি স্টপ করেছে সেই কমপ্লেন্সটা
Lord, that is also in my annexure, my lord. That is in my annexure P7. That is a subsequent development, my lord.
The district inspector of schools, AC Hooghly, shall not allow disbursement of salary.
No, my lord, DPPG. Only the no liability would be issued by the teacher.
Give the submission of no liability certificate.
Comply, my lord.
With the first
Teacher in
and
charge is present, my lord.
doesn't
Kindly
matter,
consider,
doesn't
my lord.
matter, sorry. Did we ask her to be present here?
My lord.
We don't like this kind of person.
No, my lord, my lord. Kindly condone the cost, my lord.
Shall not release the salary of the teacher in charge until so that in future you do not do it.
My lord.
Seriously repeating with this submission,
My
seriously.
lord, kindly call.
All are your statutory authorities.
My lord,
All are your statutory authorities. You could not have verified it.
my lord,
And you are putting a pretentious face.
my lord.
The appeal succeeds. The appeal succeeds. The impugned order is set aside. Appeal and the application.
Item number 44.
Lord, I am appearing on behalf of state appellant, my lord. Sanjeev Das is arguing a matter in another court. I am praying for short passover in 44, item number 44, my lord.
Why?
Please, Mr. Sanjeev Das is arguing a matter contempt petition, my lord.
Let us see what is the matter. Tell us.
Matter was for the writ petitioner, I responded on one hearing. Actually, this is a case of transfer, and I applied for the transfer. Was working in Ramakrishna Mission Boranagar school, and my lord, I applied for transfer, mutual transfer, and what it was granted. But the school was not pleased to release me, and that is why the writ petition was filed. Only thing, my lord, in the writ court, my lord, there is some mistake. Actually, it was mentioned that I purchased a flat 25 kilometers from the school, but it is not correct. My permanent address is at Bankura, and I on rent, my lord, I was residing over there to serve my service. And apart from that, actually, the appeal has been filed by the state, my lord.
This appeal?
Yes. They have mentioned, state has mentioned one circular that has been, my lord, issued subsequent to my application for transfer. Before that, that circular was not there.
Who is appearing for the state?
I am appearing for the state, my lord. I am paying short passover, my lord. He is coming.
My lord, Mr. Vishwabroto Basu Mallik appearing on behalf of the state respondent, but he is engaged on courtroom number 1.
State respondents.
Sorry, my lord. Sorry, my lord.
Well, page 65 is the order of mutual transfer.
And adjournment is spread for on behalf of the appellants. The matters are next. Next.
ছেড়ে দিন। বিশ্বব্রত
45.
45, I appear for the application.
45.
645.
Who is for the state?
I am for the state.
No, you are for the state.
My lord.
What does your scheme says on this?
My lord, my lord scheme says, my
Any
lord,
affidavit file?
no.
You file your affidavit.
But at a very short point,
No, we have to see that what is.
the scheme has been annexed to the petition.
I will file affidavit.
Yeah, when is the scheme?
Yes.
No, where is the
But
order?
the notification
No,
that
where is the order by which it was rejected?
yes, can it turn to page 59? But that is the most important part. 59 is the order of the district inspector.
No, but it says when a teacher dies in harness, leaving a family which is in extreme financial hardship. So unless this criteria is fulfilled, you are not.
Absolutely.
Yes,
Now, my
so
lord,
order says that this criteria you have not been able to fulfill.
now, my lord, the most important part is the date.
And you are not denying that the mother of the petitioner is a teacher of a school.
But my mother is a teacher, absolutely, but
So
there is
that's
no
why-
denial.
So the family is not in an extreme financial hardship.
Now, my lord, I strongly support what your lordship is saying, but kindly see the date of the notification.
2018,
2009.
2009, yes.
And my father expired in 2007. This notification was not born.
No, but 2007, if it is there, so you are minor at that point of time.
Yes, I was minor.
So any application was made, when your application was made?
Kindly turn to my-
2016, after 9 years.
my first application.
Reason order it has been stated.
আরে বাবা আমি বলতে দাও।
আচ্ছা জিজ্ঞেস করলেন আমি বললাম।
Then you submit. The first application, page 33. It was in 2008. There also, this rule was not there.
Now, the wife of the deceased, namely, is a primary school teacher under TPSC. Malda.
Yes, Malda.
Till date. Yes. So second ground, first ground may not be there. Second ground remains. The wife of the deceased, namely such and such, is a primary school teacher of DPSC Malda with effect from 25th January 2001.
Yes.
So prior to the death of your husband.
Yes.
So that question of financial hardship does not arise to the family.
But absolutely true.
Then-
But the question is when the notification came. But the notification has come 2 years after the death of my father.
So prior to this, this is a notification of
2009.
Now, what was the notification applicable at the relevant point of time?
That has not been mentioned by the DI.
2001 rules, the point is, whether minor can be afforded. 18 years, she was not 18 years, 10 years. And second point is, the financial hardship. 2 points are 2001.
When he died, see, she was a minor.
My lord,
So she could not have been considered for appointment
my lord.
during the time when she was minor. She became eligible to apply only after he attains majority.
My lord.
Very well. So you see that there is one problem. Because you will not be able to be considered at that point of time because you are a minor.
Absolutely.
So your application has to be considered when you attain majority.
Lordship.
If by that time a subsequent circular has come, that will be taken care of.
But my first application was made by my guardian, my mother. It was in 2008.
16.
No, 2008. Page
But-
33. Page 33. Kindly have a look. I know that I have a bad case.
No, it's not a bad or good case. It's that
33 is 2008. I made this to the headmaster. My mother made this application to the headmaster and prayed for.
But this will be also a financial hardship. Why you not 3 children? One mother in 2001 being able to take care of it.
My lord, the question is, my lord, the hardship is required to be, adjudicated. My lord, your lordship knows that, my lord, there was no financial hardship.
2008 when it was filed,
My lord,
she had 3 children.
Yes.
no, 12 years.
3 children.
3 children.
Yes.
3 children.
It was considered after 11 years.
Yes.
So it has to be because if it is if that time it was considered, you cannot be given an appointment.
No,
It has to be
absolutely not.
considered when you become eligible.
Lordship.
But in the meantime, if there's a change of policy, that has to be applied to your case.
Now, what I am on is
On the date of attaining majority, she is entitled to apply. Then, my lord, the subsequent circular government.
This application should be treated as an because you were unable to give her employment till she attains majority, and your rule says that on 11 November 2016 when she applied, it has to be beyond 2 years because Your DI has overlooked 15th February 2008 application.
Malad, that was not application before the DI, first one, and
Doesn't
that
matter,
was
the headmaster. Headmaster
Ma-
should have
yes,
forwarded it.
Malad, school is a Malad different body, not made, and Malad, the new application made by the petitioner because she was minor. Minor is not entitled to apply. Malad is taking the hardship point. Malad, I got it.
So at that time, she was able to with 3 children, and she was the only lady working in that. It's certainly a hardship.
Malad, hardship means Malad, there is a Malad, there is a Malad cut up point. There,
Let the second
Proof
application
I
was
will-
also
I will
made to
use
the headmaster
affidavit,
by
Malad,
me.
disclosing the relevant
Not
rules.
required, not required. Take it down.
Because my relevant rules,
Of the-
minor cannot
of the
be.
District Inspector of Schools, Secondary Education, Malda.
Primary.
The decision is at page 59. Where's the decision?
But at page 59.
Yes.
But she's a primary, but he is a primary teacher.
Secondary School, Malda, dated 22nd March 2018. The subject matter of challenge in this writ petition. Is a subject matter of challenge in the writ petition. The learned single judge has dismissed the writ application on the ground that the
এটা একটু
mother of
জটসাপকে
the
দিন বইটা।
petitioner is a teacher of a school.
এই যে, টিক দেওয়া আছে।
School, and the purpose of giving compulsion appointment is to tie over immediate crisis faced by the family members for untimely death of the bread earner.
তোমরা তখন এটা কনসিডার করেছো না? কখনো অ্যাপ্লিকেশনটা হেডমাস্টারকে দিয়েছিল ওরা। হ্যাঁ।
The father of the petitioner, the father of the minor, was a teacher.
Yes, primary school teacher.
No, he was a high school teacher.
Primary teacher. Malad, in primary, Malad, in primary school, if teacher dies and the spouse or Malad, the children do not have the requisite qualification or training qualification, her name or his name will be sent to the Malad, to the secondary.
I stand corrected. He is a high secondary teacher. I stand corrected. Secondary.
Father of the minor
Secondary.
was a teacher. Moreover, moreover, even if an application is filed Next.
Can it be taken up, my lord, 16, my lord?
Yes, see.
My lord.
48.
Mr. Pitam Choudhury appearing for the appellant. He's not well, my lord, paying for not this week, my lord.
Not this week. Next.
Grateful, ma'am.
49.
49 and 50. But I appear for the appellant.
Yes.
But having no fault of mine, but I have been penalized by the Honorable First Court.
You are appearing. Have you served?
Yes, yes. But already, sir, Mr. Bari is appearing for the. But this is my affidavit of service for the writ petitioner.
Where is Miss Kweli Church?
But Mrs. Kweli Bhattacharya was there. But আজকে দেখেছো? ও এসএসসি তো তুমি আছো তো? Mr. Dr. Sudhanu Patra is for the School Service Commission. আমি তো টিচার। এটা বার করো, ট্রান্সফার রুলটা বার করো। কেটে দিতে। শুনছেন যে করছেন অর্ডারটা?
Yes, Miss Bhattacharya, yes.
এটা হচ্ছে মানুষটা প্রথমটা যেটা আমাকে ট্রান্সফার করে দিয়েছিল, আমাকে আবার ব্যাক করে দিয়েছে।
He was transferred contrary to the rules.
No.
That is a.
And Mr. Bari is appearing in this matter and on behalf of the private respondent, my lord.
This is a matter of transfer of the petitioner from her.
School given no objection certificate to the applied for transfer. School have given a no objection certificate, and on basis of that, School Service Commission has recommended for transfer, and we have issued an transfer order. Now, my lord, the petitioner, the other person, issue সংযুক্ত রায়ের মধ্যেই তো?
না না সংযুক্ত রায় নেই। মানে I tell you, Lordship, what has happened?
This is Papia Shen Modok.
Papia Shen Modok and myself, both are teachers of a school in Purulia. Both of the teachers, they have applied for transfer. Now, my transfer was, my papers were sent to the District Inspector of Schools only 3 days prior to the papers of Papia, the writ petitioner. Now, I was transferred to some other school. Papia Papia could not be transferred because she became the single teacher. Now,
so by reason of transfer, Papia became the single teacher.
Single teacher.
But Papia, in terms of the transfer rules, he was entitled to transfer.
Yes. Kindly have a look to the rules.
What's wrong with this?
No, may I?
What's wrong with this?
There's
nothing wrong with this order, and it's perfectly justified because the teacher in charge was managed.
No, not management. The second appellant will be the teacher in charge. But you see, what penalty he has faced. But we are enjoying an interim order.
11th May, the matter was supposed to appear before the learned single judge. What happened on 11th of May?
The matter did not appear. By this time, because of this order, now Papia has been transferred. I have been left alone. in that school. But after the order of the single judge, Papia has been transferred because I have been returned back to my home district, home position. So initial position I am holding this school, and Papia has been transferred.
Papia has paid for transfer to another school.
To another school, I have paid for another school. Only 2 days.
Papia's application, if it is considered first,
Hmm.
then she would have been in that school.
But only one thing I want to show to your lordship. I justify the order passed by the Hon'ble single bench, but on the strength that rule 5 sub rule 6 says the school authority on a particular school.
For the appellant, you are for the appellant.
I'm for the appellant.
Yes. You are justifying the order of the single court.
But only to that extent.
Only to the extent. What extent?
Only to that extent.
Partly good, partly bad. Yes.
But
Partly valid, partly invalid.
But kindly allow me for 1 minute. Now, these
teacher in charge is the mastermind, no doubt about it.
No. I also.
How do you know? No.
I also defend him. In the next matter, I'll be defending him. But you will see.
That is what you are saying. That is why I'm saying you sent his application.
No. But he has sent both the applications.
No, just now you said 3 days prior to.
Only this is the anomaly.
Why it should be? Absolutely, we are not doing it. We are not.
But your lordship kindly allows me.
Application was sent 3 days after. Manu's application sent 3 days prior.
3 days prior. But both the
This will be considered by the learned single judge. Let the learned single consider this. Stay down.
Your lordship kindly allows me.
Then my approval has been accorded by the DRBC.
Then she has been transferred. Her application has been accorded in another school, but I have been left.
No.
What wrong I have done?
You have manipulated for
No, not at all.
Then let this Bhushan Hasda file an affidavit with the learned single judge.
But that was done. But that was the direction of the learned single judge.
Yes,
The learned single judge has stopped the salary.
11th May, the matter was fixed.
The learned judge has stopped the salary of the teacher in charge. But we got an interim order, and he is discharging his duty.
Where is the interim order?
Next my item.
Where is the
50.
No.
There is a question of managing. This is not understanding the rule.
Not understanding the rule.
Only this much. Well, the teacher in charge, he may not understand the rule as we.
But he's the teacher in charge. He's not understanding the rule, but he's the teacher in charge.
But
So
if your lordship.
We ask for order of removal, order of demotion.
Proceed who is the teacher in charge?
Ojo Thala. No. There is a question of demotion. I'm a teacher. But I will be.
No, then we'll pass an order that you are not competent and eligible.
Then Manu should be teacher in charge. Only 2 teachers are left.
Will not be ever entitled to become a headmaster.
Yes,
Yes, because you are not understanding the rules.
Your lordship kindly.
Lack of understanding to understand the rules.
Kindly.
Teacher in charge of
Emni Bashkachi. Tarauna. Kindly have a look to the rules. Hey, Joseph, ke boita din ekটু 656 2015 rules. ওইটা দিন, ওই হেডমাস্টার ম্যানুয়ালটা দিন, 1 ভলিউম 1 নীলটা নয়, ব্লুটা নয়। হ্যাঁ, এটা দিন। বার করো। ওই অ্যাপয়েন্টমেন্ট কনফার্মেশন অ্যাপ্রুভাল ওইটা করো। দাও।
Hello. 5950. In person.
56 rule 576
In person.
না না জজ পঞ্চাশটা বার করে তো টিআইসি না হেডমাস্টার
নাম কি ছিল?
ভুবন টিচার Your Lordship is reading. ওই ছিল তারপর তো স্টে পেলাম এন্ট্রি অর্ডার পেলাম পরেরটা 50 টিচার ইনচার্জ না না হরিষ্ঠ না না অরিজিৎ ব্যানার্জি জাস্ট অরিজিৎ ব্যানার্জি না না এটা ফার্স্ট অর্ডারটা বাদ করো অরিজিৎ ব্যানার্জি
Yes.
Whereas my lord has seen the entry order.
But if you have now been transferred and she's also been transferred, is merely an academic now.
Now she has no grievance. She has been transferred.
I have transferred and my approval has been accorded by the DRP schools.
So you have been transferred to
I have been transferred from this school to another school.
where you have asked for.
Yes.
Yes.
That was processed and allowed.
Yes.
Yes. But I have been sent back
to save the DI. Disciplinary proceeding as a say DI.
Yes. But I have been sent back to this school, original school.
No, so to save them from imminent danger of being prosecuted, the DI has changed his stand now.
2 appeals were filed. One by DI, one by the teacher in charge.
But we are not satisfied with the explanation for not sending the application, her application first. No
But it
explanation
was
offered.
it was misunderstanding of this law.
Misunderstanding.
Lordship. But I must candidly submit for the.
Then you are not entitled to. Then you
I will lose the post of teacher in charge. Manush will be the teacher in charge. Well, I will remain a teacher, as nobody is the headmaster. So, but I became the teacher in charge. I will quit. I'm not getting a single penny more.
No. How many applications you have processed in your life for transfer?
2.
And how many misunderstandings you have?
2, only 2. There are 3 teachers. Only 3 teachers in the school.
You have said so that this was by reason of your incorrect understanding of this. Have you said so anywhere?
But then after my lord is looking at 50.
No, the one you have handed over. Did you say that in the affidavit that this was because of your whose application has
No,
to be
but
sent? Because when the transfer rules clearly say that the senior case has to be forwarded first in no uncertain term, if that simple language is not being understood by a teacher who claims to be the headmaster, then he has no business to impart education to the students. If he lacks this kind of basic understanding of the.
Well, it will be too harsh.
No.
It will be too harsh. But
Sometimes code has to be harsh.
I tell you, Lordship. I tell you, Lordship. Kindly seize the
name of the teacher in charge once. Kindly seize the name.
We are not concerned with the name.
Bhuvan Kumar Hasda.
Yes.
But
So,
Bhuvan Kumar Hasda, what I wanted to say, so is not the answer. The answer is Hasda from a tribal community, a tribal community. He comes from a tribal community.
no, whatever is the tribal community belongs to, once he becomes the headmaster of the school,
Teacher in charge.
yes, headmaster, whatever nomenclature you may use, so he's the head of the institution.
At present.
So it is presumed that he understands the provisions for transfer and everything.
I tell you, Lord Shubhra, there are three teachers. Bhuvan, Manosh and this.
Bhuvan, Manosh, Som, whatever, we are not concerned.
Being Hasda, he is not entitled to become a teacher. So when he got the appointment as a teacher, he must be that much qualified.
Correct.
That thereafter, he has got
much qualified.
So and lack of understanding of the rules.
So what is trying
it is
the catastrophe for the school. Catastrophe for the school. With the audit and other things, if he is not understanding the Control of Expenditure Act and other provisions, then he is not at all competent to become.
Your lordship can easily understand. They are in academic field.
Well, in other words, he's saying that he is not competent.
Why board is so agitated? I simply don't understand. Board has no function here.
Why Hasda? Why
No. What board has?
Board is assisting the court.
Board?
Assisting the court.
Assisting the court.
Absolutely.
But a board has no function here.
We are not at all happy with the explanation offered for not sending the name of the lady.
Names were sent. Names were sent
after 3 days.
After 3 days.
By that time, DI has processed his application, so she became a single teacher.
Yes. Now,
the cash is there, and how much money transferred?
That is not.
How do you know? How do you know?
I tell you, Lordship.
No.
By the intention of the teacher in charge speaks.
How do you know?
I tell you, Lordship, because
who has given you the intention? You are arguing a matter on his behalf. That's all.
Yes.
Don't proceed more than that.
But the intention is.
Don't put your case that high.
I tell
if you fall, it will be in pieces.
I tell you, Lordship, he has sent both the names, but within a
that is a vital 3 days. That is vital because by that time she became a single teacher and not considered for transfer. Now that is being restored because DI realized that he made a mistake. Hasda realized he made a mistake. So now it is being reversed.
The DI should have considered this before forwarding the name to the School Service Commission. On the very next day, DI has not forwarded. But it was kept in the.
Should I appoint a CBI to investigate how many matters DI? And you will be behind the bar until such matter is being decided.
But I don't want to.
Don't put up such things. Take down.
But kindly, save that person, because either there will be an investigation or not. But the court has directed for investigation and the punishment. Kindly, save me from that.
Investigation should be there.
Absolutely, but I am welcoming that investigation because what has fallen from your lordship, whether the monetary transaction is there or not, let it be unearthed. I may not be suspended for this.
He himself is saying Hasda he cannot understand.
How the board is so? No, I simply don't understand. No, you are the officer of the court, but you have no business here.
Both the appeals are taken up. Both the appeals are taken up together and disposed of by this common order.
Why you are not saying for this DI?
Stop.
I don't know the title of DI. You tell us the title of DI.
No, question of title. Title does not arise. DI is also a government officer.
Will you allow us to pass an order? Will you allow us to pass an order? No, side talks, please. The teacher in charge of Penchara Junior High School is agreed by an order by which disciplinary proceeding was initiated against the teacher in charge for his acts of omission. Please listen to the order.
Yes, I'm saying.
Acts of omission in not forwarding the application for transfer of one Papia Shen Modok in time and and appears to have been proactive in sending the application of one Manoj Ghosh. One Manoj Ghosh, who admittedly was junior to Miss Modok. It is admitted that in order of time, the application of Modok ought to have been sent to the DI for consideration. By reason of sending the application for Manoj Ghosh earlier in point of time, the said application was processed within a very short time, and the DI having allowed the said application for transfer was processed unusually within a very short time, and by reason of the order of transfer in favor of Manoj, the application of Papia could not be considered on the ground of single teacher post. It is not in dispute that the teacher in charge of the school was required and obliged to forward the application of Papia prior to Manoj, and this seems to have arced IRK of the learned single judge in directing disciplinary proceedings to be initiated against the teacher in charge for such act of omission and negligence. However, as it stands now, Manoj has been reverted to the parent school, and the application for transfer of Papia was allowed, and she has been transferred to the school where she wanted to be transferred. This was allowed by the DI. Full stop. At the time of admission of the appeal, an order was passed by the coordinate bench on 26 May 2022, where it was observed that there was no adequate material before the learned single judge for holding that the teacher in charge is guilty of misconduct, and there cannot be any justification in restraining him from entering the school premises. The order directing the order directing stoppage of payment, of salary of the teacher in charge was, however, recalled by the learned single judge. In view of the changed circumstances, we are of the view that there is no necessity for us to decide the matter, to decide the appeal on merits. However, we direct the commissioner to hold an inquiry with regard to the omission of the teacher in charge in not forwarding the application of Papia in time, and also the conduct of the DI
Purulia. DI AC Purulia.
DI
Secondary education.
Secondary education.
DI AC Purulia with regard to the processing of the said application within 3 days, as it appears that the application for Papia had reached the said office after
We can say.
office soon thereafter. The commissioner shall be at liberty to decide on will be the commissioner of school education shall be able to decide the course of action that may be taken in the event any adverse finding is arrived at against us, against them. Adverse finding is arrived at against both or any one of them during investigation.
Commissioner of School Education.
The entire process shall be completed within a period of 8 weeks from date.
But if your
On
lordship,
the date of communication of this order by Ms. Koeli Bhattacharya appearing on behalf of the
West Bengal Board of Secondary Education.
West Bengal Board of
In both the matters.
let both the appeals are taken
Appeal
together and
applications
disposed.
are accordingly and disposed of.
Disposed of.
The impugned order
Yes,
is modified.
no, this will be filed before the learned single judge. The findings of the commissioner.
But I couldn't follow the.
The findings of the commissioner shall be filed before the learned
Plan
single
is
judge.
single judge.
Demoted.
कोणाला घेता हवंय तुम्ही?
That will be a big hurdle because your lordship has directed the commissioner. She has been placed where she wanted.
That is not the thing. That is not the thing. Very well. The impugned order is set aside.
Grateful.
The
Grateful.
impugned order stands modified to the aforesaid extent.
Modified. Grateful.
Appeal and application stand disposed of. Yes, next.
51.
My lord, 51, my lord, I am for the appellant petition, my lord. This is coming up for the second time. My lord, my matter is, I joined in a school as a primary teacher in 2006. Thereafter, in 2006, after my joining, I sought for transfer. I on my own sought for transfer. In 2010, my lord, I was a stay. My lord, Mr. Bhaskar Prasad Busho appeared last occasion and there was a direction to file a report, my lord. My lord, my contention, if your lordship sees, my lord,
Someone appeared, came later on and said that a report is ready.
my lord, not on facts, my lord. Only thing in 2010, I
What
on
is
my
the Board of
application,
Dash?
my lord, Board of Dash.
Board of Dash to provide them.
My lord, I am calling. এখান থেকে গৌরবের নাম্বারটা একটু ফোন করুন। My lord, in 2010, on my application, I was transferred in a school. In 2017, a new teacher was appointed in that school. Suddenly, my lord, I was transferred on the ground that I am a surplus teacher. You are the excess teacher, you are transferred. My point is, my lord, government can transfer me, no issues. I am not on that. But when government is transferring me specifically on the ground that I am the surplus teacher, when I am the senior most teacher, there I join issues, my lord. I am not, if the surplus word has to be defined, my lord. Every time the government wants, I am not the blue-eyed boy, I am transferred. If your lordship kindly comes, my lord, only once.
No. Is it your case that you are the senior most teacher?
Yes, my
who was
lord.
transferred?
Yes, in 2010, I have joined. In 2017, another teacher was appointed. That teacher was not transferred. I was transferred being a surplus teacher. Government can transfer me, no problem, but not on the ground that I am a surplus teacher. And your lordship, if your lordship kindly comes to my lord, page 43, my lord, once. Page 43.
Matter to refer to. No, but we need to see the report. Take down. Take down. State is not represented. The report directed to be filed. Directed to be filed by the DPSC South 24 Parganas, clarifying its stand, has not been filed as yet. Suspension, you have challenged the order of suspension.
Suspension followed by order of discontinuation. The writ petition was allowed partly, my lord, straightway turns to page 40 of my writ petition. Of the application, my lord.
It's required to be heard. There's no scope for interim order.
Yes, my lord. My lord, kindly, this can be disposed of. Subject to kind sanction from my learned friend. The learned single judge allowed prior brief, my lord, straightway turns to page 40 of the application. That order of suspension and discontinuation was set aside by the learned single judge. But there was specific prayer B Roman 2 for reinstatement. That has not been allowed.
No, but why that was refused?
Nothing. Page 80, the order in relevant portion, paragraph 15.
If you have a sure.
Well, by this appeal, my lord, the petitioner is trying to create a right of permanence in the post, my lord, which he doesn't have.
No,
He
that's
is
a different issue. Once he was in service. So his service was discontinued.
He's a temporary staff on a no work, no pay basis.
No work, no pay. There's a different. There's a different issue.
So there should be at least why the prayer B to B Roman 2 was not allowed. Or subsequent to the
Because if you are a contractual basis staff, if you are on a contractual staff.
No, my status is casual worker on temporary basis.
Yes.
So far, no work, no pay basis that I have heard from my learned friend that I have to take instruction whether.
It was on a no work, no pay basis.
That is my instruction.
Probably not.
No, but
Probably
if you see, if he's then the disciplinary rules that you have, that must also say that if the disciplinary rules, if he's acquitted, then what would happen? The rules must provide for it. If you are proceeding against him on the basis of the rules must say that in case he is acquitted, then what is the remedy?
Here, my lord, a full-fledged inquiry has not.
You have initiated inquiry on the basis of some rules?
Yes.
What are the rules?
But the non-teaching staff rules will be applicable, but
If
whether
it is non-teaching staff rule applicable to him, then he's entitled to all the benefits of that rules. He's entitled to the benefit of all those rules. You cannot say that because if one is granted, two is automatic.
my lord, I shall come back with that, my lord, whether it applies to temporary staff also, my lord, because
Then your entire initiation of the disciplinary proceeding is wrong. It has to be based on some statute, some rules. Now, if you have initiated on the basis of which rule you have initiated?
it was show cause, my lord, at page 62.
Yes, fair enough.
The rules is the Vishwabharati non-teaching employees terms and conditions service rules 1976.
Where is your appointment letter?
Page 43 is the office order, my lord, wherein these certain persons were engaged, my lord, petitioner being one of them.
Rule 47.
Yes, in all other matters related to service, including conduct of the casual, will be governed by the service rules for the non-teaching employees.
My lord, the contention of my learned friend, with my respectful submission, is not correct. If your lordship kindly turns to page 32 of the application, wherein I have stated the petitioner is not paragraph 20, my lord.
Yes.
This rule is not applicable to the person. The categories are mentioned.
Chapter 5 of
Therefore,
the state rules deals with penalties. A person on daily wages, a
a
person.
person on daily wages. So I am not a daily wages worker.
So which rules? Because if he is, because he has also a right to be considered for absorption, regularization. Right to be considered. Whether it will be there or not is a different issue. But there is already, there is a scope for it.
Yes. Yes. And my lord, as far as
One thing more, my lord, after the order was passed by the learned single judge,
Statement, yes.
I have made a communication to the authority for reinstatement. That has not been considered. It was told verbally that unless there is a specific order from the court, we cannot allow you to reinstate. That appears at page 52, man.
once the discontinuation of engagement is set aside, then he is restored to that position.
Well.
He is restored to that position. So how you can, because you have not disengaged him in terms of this office order. There are specific stipulations
Yes. Clause
where
9.
it can be disengaged.
Clause 9.
So none of this is applicable to instant case. So he's required to be reinstated. Then whatever procedure you have, you follow. That's a different issue. If you feel that it's not required, but reinstatement as a matter of course.
But may I come back with the rule and the affidavit used in the matter? That has not been annexed here. The affidavit used.
The writ petition was allowed by setting aside.
Specific order ছিল যেখানে আমাদের
By setting aside the
মানে affidavit
by setting aside the impugned order dated 13th August 2019 passed by the registrar bracket acting Vishwabharati, by which the engagement of the petitioner was discontinued. The order of the learned single judge is not has been accepted by the university. The grievance of the petitioner is that although the impugned order was revoked, was set aside, but the consequential prayer for reinstatement was not allowed. It appears that the learned single judge has set aside the communication dated 13th August 2019 and the orders of suspension Normally, when the order of suspension is set aside, it restores the original relationship between the parties. The learned counsel on behalf of the Vishwabharati has prayed for an adjournment to take appropriate instruction in this regard. The matter is adjourned for 1 week. Now, you could have approached the trial court also, the learned single judge for this.
Since there was no specific reason or
No, because possibly what was thought of is if that portion is set aside,
my lord, I have made it. That is why, my lord, I have pointed out PG.
if that portion is set aside, then your service is automatically restored. That is why suspension was set aside. So if one is set aside, so that was, so you should have approached the learned single judge.
Considering that, my lord, I have approached the Vishwabharati to reinstate. That has not been.
No, that is why you should have approached the learned single judge, because that is a different thing. It was better for you to approach the learned single judge and to seek a clarification on this. You think about it and let us know.
As your lordship.
Because Vishwabharati has not officially wrote any letter to you. This was a verbal communication on the basis of you file the writ.
No, well, that I have
File
communicated.
the appeal.
No, well, that I have communicated. The order has been communicated with the prayer to reinstate.
So you could have filed a contempt before the learned single judge.
Instead of let me.
Because it is better for the learned single judge to clarify on this point. Because once the suspension goes, so 2 is automatic. So if it seems that this was not really allowed, then possibly
Appeal would have been
prefer an
preferred. Yes.
So what do you want us to do? Tell us.
To modification of that particular order,
You could have applied for the learned single judge.
in that even, my lord, kindly make an observation so that because already I have made.
No. Appeal will be on what basis? You are affirming the order. You said consequential benefit was not granted. So once the suspension goes, then 2 comes automatically.
That is
Will you come also, because that is automatic. That is automatic. Very well, call the list.
Lordship. Item number one, Lordship, personal appearance has been given to the chairman.
Yes,
I am
because
uncon-
reports
I
are
am-
not being filed for
I am
3 months.
unconditional apology, Lordship, the matter will, Lordship, I am sorry, Lordship, matter-
But where is the report? Report has not,
Report, Lordship, I am giving a report, Lordship, next day, Lordship, or 1 week of adjourn the matter, Lordship, I am assurance.
who has taken the order? Who has taken, but no one appears.
No,
You are
Lordship,
not
I am
appearing, you are saying-
I am sorry, Lordship, I am conditional. Only
কি
personal.
অর্ডারটা নিয়েছে?
আমি 51
কি বলেছিল? No, the state is represented by Mr. তারপরে কি আছে?
এটা 1
Represented by নামটা দিয়ে দাও। Mr. ভাস্কর প্রসাদ বৈশ্য, তারপরে
But I appear for the appellant writ petitioner.
53
yes,
My lord, affidavit of service, we can read the record.
this is for the state.
But I have got the NCT.
What does this matter?
The school service commission is the main authority here, answering respondent. The fact of the case is, my lord,
Personal evidence. সেটা হ্যাঁ সেটা দেবো ও 965 ম্যাট একটা এখানে হ্যাঁ দেখছি ফাইল মিলাবার সময় দেখছি পুরো কথাটা জানো কি বলে ডিস্টার্ব হলে কিছু না বুঝতে পারছি নিজেদের মতো বসি নিজেদের মতো এনসিটি লিস্টে বিএড ঠিক আছে বিজিবিটি এটাও হয় না কোথাও পাচ্ছি না না বিএড ফিজিক্যাল এডুকেশন ওয়ার্ক এডুকেশনের কিছু আছে এটা দেখছি না সব তো আলাদা রুলস আছে 2014 রেগুলেশন এগুলো সব যে যে যার মতো নিজে বসে যাচ্ছে কোনোটাই ভ্যালিড কোয়ালিফিকেশন সবসময় পিজিটি মানে পিজিটি এইগুলো আছে বিএলইডিটা হয় বিএলইডিটা হয় বিএলইডি কে অন্য কিছু না অর আছে সেন্ট্রাল গভর্নমেন্ট নোটিফিকেশনে অর আছে এইগুলো সবকটা হবে বিএড স্পেশাল এডুকেশন তো So equivalency not established.
My lord, while my lord,
Equivalency not established.
let me give one clarification. My lord, page 96, your lordship was of the view, his lordship was of the view, my lord, 2 year has been decided by the appropriate authorities to be equivalent qualification like BT, B.Ed, PGBT, PT. My lord, I say, my lord, the learned judge has not considered the NCT notification, my lord, amended notification 29th July 2011 at page 71. NCT was a party, but may not have appeared before the learned court below. My lord, page, page 71, NCT notification dated 29 July 2011. Page 71 of my stay application. Application for appropriate orders.
Page
71. My lord, kindly see.
This is for the primary teacher.
No, 6 to 8. 6 to 8, upper primary.
Oh, this was amendment to the notification.
Yes, well, these notifications were not considered in the entire order. My lord,
But
may I
you-
just read
You
out?
have not annexed this.
It was annexed, my lord.
Who is for the state?
Well, answering respondent is the School Service Commission.
Who is appearing?
But Mr. Konak Kiran Bandyopadhyay appeared before the
But have you
learned
served?
court below. Yes, it is, sir. My lord, affidavit of service.
What do you say, Mr. Nondi?
My lord, my little submissions were since I was not served the copy of the writ petitions because this is 2014 writ petitions, they served upon earlier standing council. Now, my lord, I have not been served, therefore it was not within my knowledge, and for that reasons I could not assist the learned single judge. But my lord, so far the notification dated 29 July 2011 is concerned, my lord, if your lordship kindly come to clause 2 of this notification, which is applicable for class 1 to 8, that is upper primary. Here, my lord, 6 to 8, that is for upper primary. Here, my lord, it is my responsibility, it is equivalent. DLED or, my lord, it said so, DLED or 1 year B.Ed. So for these qualifications are concerned, all are equivalent.
My lord,
See the
graduation
or.
and 2-year diploma in elementary education or.
Under clause 2, 1 II, clause 6 to classes 6 to 8, A, graduation and 2-year diploma in elementary education. That means DLED or graduation with at least 50% marks and 1 year B.Ed. So if a candidate possess one second kindly consider. 1 second, that is if a candidate possess graduation and 2-year DLED program, he is equivalent to with a candidate having graduation with at least 50% marks and 1 year B.Ed. So for this, the subject matter of the writ petition is concerned, the grievance is there is 6% marks, which was not awarded in favor of the candidates who possess DLED. My responsibility submission, it was wrongly done by the commissions. If a B.Ed candidate is entitled to get 6 marks, then DLED candidate also get 6 marks. As per NCT notifications.
The previous notification was tired. First notification is to BA BSc graduation course. Page 67.
No, but you are having a graduation with 2-year diploma.
Yes, my lord. I am having a graduation with 2-year diploma in elementary education.
So a candidate, he possesses graduation with DLED, if he is entitled to teach for upper primary 6 to 8. Similarly, a candidate having graduation with B.Ed, he is also entitled to teach upper primary. So they are equal. So for their qualification is concerned.
State, anyone is appearing for the state?
They have framed their guideline contrary to NCT guideline.
But this was, my lord, in respect of the previous selection process. And my lord, recently, my lord, all the rules have been changed and made equivalence with NCT.
But this change of rules.
And my lord, in the rules also, my lord, in the
Take out.
state rules, it is also there.
No one appears on behalf of SCC. Now,
Yes, my lord. Well, led by Mr. Pinakit Phul, my lord.
Any affidavit required? Have you filed any affidavit with the trial court?
No, my lord. In this stay application, my lord.
No, my lord. In the trial court, no affidavit is there. My lord, only first day, my lord, the petition was disposed of. So then, my lord, against that order, my lord, my client prefer an appeal. In the appeal court, my lord, direct the state respondent to file affidavit in opposition to the application and appropriate order.
What is your prayer?
My prayer is, my lord, my client is my lord, school group C staff. She was prevented by the my lord political party. As a result, my lord, near about 4 years, 5 years, he has not attend his normal duties. As a result, my lord, my lord Justice Dipankar Datta, his lordship then was direct to join the post. He joined. My prayer is my for your lordship regarding the increment. My lord, there is a circular. Right? If any employee under duress, he is entitled to get the my lord, increment. My prayer is my lord.
How the duress can we here prove it?
Yes, my lord.
How the duress can be proved in this proceeding?
But duress, my lord, I have filed my, several complaints before the officer in charge on local police station.
Any 156.3? Any 156.3?
No.
Means
I was
any 156.3 we asked.
I was restrained by the political party.
156.
It is revealed from the order.
FIR.
FIR is my complaint is there.
FIR lodged.
No, I have filed a complaint.
If they have not done so, 156.3 is your there. Have you made any 156.3?
No.
Then matter ends.
One thing was subject to correction, my lord. The circular is there, my lord. Your lordship kindly consider the circular. Well, I am giving the circular, my lord.
Sorry, take down.
Subject to 1 minute. 1 minute.
The appeal is arising out of an order
in the circular, your lordship kindly consider it, my lord.
Which circular?
Kindly consider it.
Which circular? Which circular?
My lord, the circular, my lord, page 112, my lord,
You have not.
period
taken-
of their absence.
You are not being able to demonstrate, you have not filed any 156(3).
I have not filed any, but made complaint before the officer in charge, local police station. Well, kindly see the complaint. Well, kindly see the complaint, my lord, page 51. The officer in charge, Marida police station, I have made complaint. But I have not, but that was not treated as a FIR. But I have not made any application before the magistrate 156.
No, then you have to have, and sorry, then you have to have 156(3).
Yes, but I have not done so because I am prevented by the political party because my life is there. It was, my lord, pointed out by the learned single judge, my lord, why my lord Judge Dipankar Datta, says 63. If at all the petitioner resume duty as clerk, he shall be entitled to necessary payment allowances.
The authorities did not find
Yes.
that because the court did not pass any order, the court only directed the DI to consider your case. And the DI did not find anything to show that you are actually prevented from by political disturbance.
Yes. But page 63, your lordship, kindly consider it. Page 63, my lord Justice Dipankar Datta, his lordship, then was. My last paragraph. If at all the petitioner resume duty as clerk, he shall be entitled to necessary payment or allowances as per entitlement from the resumption. As your lordship reserve, my lord. But this paragraph,